All right, you are all set to go, Madam Chair.
Thank you very much. Good morning, everyone. I'm going to open the hearing on House Bill 541. And I would ask the prime sponsor, Representative Betty Gay, to go ahead and introduce her bill.
Oh, pardon me, Madam Chair. Could you please read the 91A script and do a roll call?
I was just like anxious to get right to work. Sorry. I'm so discombobulated this morning. Please forgive me, everyone. Okay. As chair of the Children and Family Law Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee. An executive session may follow. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Report website. The notice for this meeting complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Christina Dyer is the staff assisting us. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states they're present, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Madam Clerk?
Hi.
Hi.
That's okay. That's my maiden name. Representative Rice, would you please tell me what the LOB room number is?
We are in 201 and 203.
Thank you. Representative DeSimone?
Here.
Are you at the LOB?
Yes.
Representative Yokella?
Present. I'm at home alone.
Representative Lewicki?
I am present at the LOB.
Representative Belanger, I'm sorry.
Present at the LOB.
Representative Cross?
Present at the LOB.
Representative Litchfield?
I am present. I am remote and I am in the room alone, but I do have my husband and two of my children here that may be in and out.
Thank you.
Representative Smith?
I am home and I'm alone.
Representative Long?
I am here in my house alone.
Representative Ali Sayed here with my new puppy. Representative Grossman,
Good morning. I am here at my home office in Exeter, and my husband is in the house as well.
Representative Levesque,
I am here at my home in my kitchen alone.
Representative Waithier,
Thank you. Good morning. I am home with my husband and 3 children will be joining me sometime. They will appear here.
Representative Patrigno,
He's going to be late. He already emailed me.
okay. Madam Chair, if they can let myself or Christina know what time they enter for the record when they do come in late.
Definitely.
Thank you. Representative Haltschiller,
Good morning. I'm here in my office in Stratham alone.
thank you. Thank you, Madam Chair.
And I am here in the LOB.
Thank you, Madam Chair.
Okay. All right. Now I'm going to open the hearing on House Bill 541, and we will start with Representative Betty Gay.
Thank you, Madam Chair, and thank you, Children and Family Law. I'll just do a sound check first. Can you hear me well?
Yes, we can hear you.
Great. And I did dress up. I didn't realize, well, it makes me feel better. So my bill is House Bill 541, relative to the priority of child support payments over other court costs and expenses. As I keep learning about family court, there are lots of different kinds of expenses. So the text, it really speaks for itself. In any proceeding to enforce the payment of child support, which would bring up the thought of somebody claiming that they no longer can afford their child support, so they would come to court or be asked to come to court when they didn't pay. So in any proceeding to enforce the payment, both parents shall submit a financial affidavit regarding income from all sources, including those used to pay all costs either assessed by the court or optionally associated with the proceeding, such as, but not limited to, fees for guardian ad litem, visitation centers, and legal representation. And the payment shall have priority over the payment of all other costs assessed by the court. Payment of child support shall have priority over the payment of all other costs assessed by the court or associated. There is from the sad stories that I've learned, and I'm sure you've heard many more than I have on this committee, child support is critical. And unfortunately, it doesn't come first. And when children grow up in poverty, they do not thrive. And it doesn't sound like, this is supposition because I don't have any proof of it, but it sounds like the state does not have a lot of money to spend on financial, let's see, there's a special word for it, but it means digging into somebody's finances. So we're pretty much left to trust what the parents display. And my concern is that there are lots of kids not getting child support who then are being supported on the not so wonderful amount of money that our welfare can provide. So this is, my main concern is the children. But as taxpayers, we could also be concerned that some parents are not paying and putting the burden on the state. And it's not it would be hard to maintain a home based on the welfare payments. And again, I'm using old-fashioned terms because I'm sure there's a better term than to say welfare, but state support, which of course is critical for a child to have some kind of support. So that's really my whole concern is the children and the fact that they don't always get child support from parents who can afford it, but don't have to prove it, and it's not easily proven. So I would like it to be a requirement that they show where they're getting the money to go to court to pay their other assessed, because they may not be showing that. We know for sure they don't always show it. And my information comes from people who have worked for a safe place in Haven for many years. So with that, I'll just open myself to any questions should you have some.
Thank you, Representative Gay. I have a question. So in this bill, you're stating that their child support shall have priority over payment of all other costs and expenses. So does that include their attorney? Are we going to be denying people due process and the right to have an attorney represent them in a parenting plan case?
That's not denying people to have representation. Usually the situation that I'm concerned about is when one parent has representation because they can afford it and the other parent does not. This is an attempt to level the playing field so that both parents have to let's see, what's the right word? Disclose the money that they're using in court. So that would include attorney fees. That's not to stop anybody from having representation. It's just to show both parents on an equal footing.
Thank you.
And by the way, I paid child support for a few years for my son. So I'm not speaking from, oh, this is a certain sex oriented.
I completely understand where you're coming from. I am still currently till this day owed $70,000 in child support. So I completely understand where you're coming from, but I would never deny my children's father the right to have an attorney.
This bill does not deny anybody from having an attorney. No way does it deny it. It's just saying that if you're spending however much on an attorney, you need to disclose where that money came from. You have a rich uncle who's giving you the money and saying, oh, here, I'll give you it. But when somebody is self-employed, they don't always have to disclose their income. And yet, the saddest stories I've heard from a person who supported people going to court who are victims of domestic abuse, but this would apply to anybody, to have a person file and say, I'm too poor to pay this child support that's been assessed to me, but they're being represented by a very famous attorney and everybody knows how expensive they are.
Okay, thank you. Representative Long.
Thank you, Madam Chair. Thank you, Representative Gray. So just for clarity, on my own clarity, the proceedings to enforce child support payment. So if I'm bringing my spouse because of failure to pay child support and I have an attorney, I'm still going to claim that. However, I still get to keep my attorney because I'm not the one that has a child support issue. However, if I'm the one going to court because I failed to pay child support and I owe $2,000, but my disclosure shows that I paid $5,000, you're saying the judge will look at that and say, you got to take 2,000 out of that 5 and give it to your child. So you're not really saying, no, you can't get a lawyer, but you are saying priority is child support over my $5,000 for the lawyer. Is that correct?
Thank you, Representative. You have really succinctly stated the situation. Yes.
Representative Belanger.
Thank you, Madam Chair. Representative Gay, when in your bill, it states a parent shall submit a financial affidavit. Are you aware if they're already filling out that financial affidavit prior to attending a child support hearing?
Is it my turn?
Yep, he asked you the question.
Okay. I think that a financial affidavit is standard for the course. What was explained to me a couple of years ago is that you don't necessarily have to put down, how is anybody going to know if you are have more income than you're showing? It's just a giveaway when you show up in court and say, I can't pay this, I'm too poor. But you have representation that everybody knows cost, easily $1,000. So that's the point here. I'm trying to make it broad enough that the situations you think of would fit. So could you narrow this, clarify a little bit more?
Follow-up?
Follow-up, Madam Chair.
Quick follow-up.
Thank you. So my concern would be, I guess if
What's the question?
yeah, I'm just trying to formulate it. So if the parent was trying to fight the child support because they are splitting custody, would this preclude them from having to pay for child support while this is still in limbo?
That's a technical legal question that I do not know. I'm just pointing out the goal, that if somebody can afford all these other court fees, including but not limited to an attorney, they can pay all these others, but they can't pay child support. That says that's a problem. The child support should come first.
Representative Altshuler. You gotta unmute. Representative, you're muted.
She can't unmute.
There we
there
go.
she is.
There we go. I couldn't unmute. I don't know what was going on there. Thank you very much. Good morning, everybody. Thank you, Representative Gay, for taking my question. Just wanted to know if the New Hampshire Administrative Justice of the Circuit Court has reviewed this and what their opinion is and what they've told you about how this would work.
I have not received any. I did not ask. I didn't know who I would be showing it to, but I also, since this is public, and I certainly get messages from people who are concerned about the subject of bills, as we all get lots of them. No one has contacted me to give an opinion, and I'd certainly be concerned about a negative opinion.
Sure. May I follow up, Madam Chair?
Go ahead.
Thank you. So Representative Kay, my second ask is this bill based on the way other states are doing this? Do we have an example of other states that bump child support payments above legal fees?
I am not aware of what other states do. However, I know we're not the worst. We're not the worst in our priorities.
Well, there's something, yeah.
Yeah, because my poor husband went through this in Ohio, and whereas we were concerned about visitation rights, they were so far behind. They were just concerned to make sure people were paying their child support. So it didn't get more sophisticated than that we knew of. And of course he did. He paid very consistently. No, it would be interesting, but if another state is not concerned about this, I don't mind being in the forefront and bringing it to the attention that children's needs should come first.
Thank you. Representative Litchfield, did you have a question? Can you use the raise the hand thing on there? Because I won't always see you actually raising your hand.
Yes, absolutely. Thank you. Thank you, Madam Chair. And thank you, Representative Gay. I feel as though this bill definitely has the purest of intent. I do know, though, as I've read through it and pondered over it the past couple of days, I have some confusion. And if I may ask two questions. One, I'm just trying to understand if there is an outsider helping to fund the legal bills, how is that relevant? So if the uncle steps in or the grandfather steps in, how is that relevant is my first question.
From a moral point of view, I'm not being polite. I really do appreciate all your questions. I just get nervous and forget the formality. If a person's is being subsidized by someone else, that is income and it should be declared. Just because you have a rich uncle who says, oh, here's a few $1,000s because I don't want to see you, quote, lose in court, that's income. They ought to be concerned about the kids. If they've got enough money to spend on an attorney, they've got enough money to help support those children. That's my opinion, and that's my moral platform.
So, Madam Chair, may I follow up on that and still ask the other question? Would that be okay?
Yep.
Okay, thank you. So my question is, I'm just trying to, and again, I understand where you're coming from, the purest of intent. I'm trying to understand, it is not the rich uncle's obligation to pay child support. It is not his child. So if someone is really in a position where they are really, truly unable to afford exorbitant child support bills, and there is a family member or a friend that is willing to step in and say, I will help you with these legal fees to make this right, I feel as though we're looking to deny that. And that's just what I'm trying to understand. So please understand, I'm not trying to be combative. I'm trying to understand the situation.
Where's your question, though?
I guess my question is, why would it be the responsibility of the person funding the attorney, for example, the uncle, to pay child support?
Which I believe that Representative Gay answered.
Okay. And then
I can answer it again. It's not their obligation to pay, but it is income for the person who's not paying.
Okay. And then
Is that, do you need a follow-up?
I do. And if this is not specifically a question, please stop me. Again, I'm just trying to wrap my head around it. I feel like it's kind of a vicious circle or cycle if someone is continuing to go to court because maybe they can't afford the child support, but yet we're pulling the attorney fees out ahead of time. I don't know. I feel like it sounds like a circular cycle. And again, my question is trying to understand.
Right. So Representative Litchfield, I believe this would be something for a work session because it really isn't a direct question for the sponsor, because I feel like you keep coming back to the same question, and I understand what you're trying to get at, but I don't think we can get there.
Okay, I appreciate that.
Question.
Okay.
May I attempt one brief response?
Yes, Representative.
Thank you very much. I promise this is it. My goal is to level the playing field. The questions were asked of me before. This is the second time I entered this subject. If one person says I can't pay, chances are the other person doesn't have money. So if we're interested in being equal and fair, the person who doesn't have money for an attorney is not being represented by a rich uncle. And if they are, they ought to be able to declare that too. So The whole goal is to make things equal and fair. We can't make their incomes equal, but we can be fair and treat them both equally. Thank you very much for all your questions.
Thank you
Thank
very
you,
much,
Madam Chair.
Jay. Up next is Karen Hebert from the Department of Health and Human Services, and she asked for 5 minutes.
Thank you, Madam Chair. I just wanted to first, for Representative Gay, acknowledge that her recognition of the importance of child support is much appreciated. Otherwise, I had subsequently moved to withdraw any testimonies, so I will do that now. Thank you.
Okay, thank you very much. Are there any questions for Karen Hebert? Seeing none. Okay, thank you very much. Up next is Erin Jacina, a lobbyist with New Hampshire Legal Assistance, and she's asked for 2 minutes to speak in opposition.
Can everyone hear me okay?
Yes, thank you.
Thank you, Chairwoman Rice and members of the committee. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. New Hampshire Legal Assistance provides civil legal services to New Hampshire's poor. Our services address the legal problems affecting our clients' daily survival and most basic needs. For more than 20 years, our Domestic Violence Advocacy Project has been representing victims and survivors of domestic violence, sexual assault, and stalking in their protective order cases, as well as in their high lethality divorce and parenting cases. I'm here today to testify in opposition of House Bill 541. I will note that I testified in opposition to a near identical bill last session, which was House Bill 1193, which this committee voted inexpedient to legislate in a unanimous 18-0 vote. I want to first address the issue of the financial affidavits raised by Representative Gay. Under Family Division Rule 2.16, in all cases in which support is in any way involved, each party is required to file with the court in exchange with the other party a financial affidavit at least 7 days prior to any hearing. On that financial affidavit, parties must indicate all sources and amounts of income and expenses. So lines 3 through 6 of this bill are, as this is already a required court practice. As to the issue of prioritizing child support payments, I think we can all agree that paying child support is an important obligation, and non-payment of child support should carry penalties. But what this bill does is create an access to justice issue and an access to service issue. So I'm just going to give you an example. I hope this will help maybe clarify things. So consider an unmarried couple with 2 kids. The dad has been abusing mom for the duration of their relationship. Dad had a decent job during the relationship, but right before filing the petition, he decides he doesn't like that job anymore, which was a relatively high-paying job, and decides he's going to take a minimum wage job. He uses the fact that mom now works much more than him and makes significantly more than him, so the kid should stay with him the majority of the time, and mom should pay him child support. So mom needs to hire a lawyer to help the court see that he is now voluntarily underemployed, but she may not be able to do that under this bill. So because mom was unrepresented, abusive dad gets parenting time that may not be in the best interest of the children. And as a result, mom, the victim, becomes responsible for paying a child support award when she should be receiving child support. In addition, this bill is asking to pit support and contact between a parent and child against one another. Child support is important, and contact between parent and a child may be important. It may be that the contact can only happen at a supervised visitation center that requires a fee. Having to pick one or the other seems like an impossible choice for those parents. Lastly, the language in lines 8 through 9 is vague and is likely to lead to confusion. the bill describes that all other costs associated with the proceedings, those need to come secondary to paying child support. But does that include payment of health insurance? Does that include payment of a mortgage or rent? It's unclear with the language currently in this bill. So I thank you for your time. I'm happy to take any questions. And that's all I have. Thank you.
Are there any questions for Ms. Jacina? Representative Long.
Thank you, Madam Chair. Ms. Jacina, so currently on the, like you said, between 3 and 5 is currently happening. So these affidavits, do they include a gift I got from a family member?
So that's a really good question. I appreciate the question. Thank you. So that absolutely should be disclosed on a financial affidavit. I will also point out that the financial affidavit is not the only document that the parties have to exchange. There is something called mandatory disclosures. It's Rule 1.25A under Family Division Rules. This was really meant to level the playing field. Because when parties are represented, they often exchange financial discovery. It's called interrogatories. But if you're unrepresented, you may not know to do that. So the court did level the playing fields and said that all parties have to comply with 1.25A, which is an exchange of financial documents in addition to the financial affidavit. So that would be bank statements, mortgage statements, retirement benefit information. It depends. There are different requirements if you're married or unmarried, but the financial affidavit is not the only financial document that is required in these cases.
Can I have a follow-up, Madam Chair?
Yes, go ahead.
Thank you. Now, with the example you gave, I couldn't follow what the issue was. You know,
Sure.
I'm the abuser who is seeking child support, and you're saying this will have the mother not be able to afford an attorney?
Well, so because you've got to prioritize child support payments, right? Under this. So she wants to comply, wants to pay her child support, but also needs an attorney to show that the child support order that the court may have issued is incorrect because he's underemployed. And somebody who is not skilled or doesn't understand the court rules, I mean, attorneys have a hard time doing this. So someone who is self-represented trying to go to court against her abuser to show that a child support award is incorrect or that the award should go to her would be really challenging to do without an attorney. And I think that's what this bill does. It essentially says you can't get an attorney, and that's an access to justice issue.
Okay, just one more follow-up if I may, and it'll be brief. Thank you. So am I hearing you correctly? I want to be clear on what you're saying. So I'm hearing you correctly that it's more important for the mother in this example to be able to use her money for an attorney than it is to pay child support.
I'm saying it's an access to justice issue to make sure that the person who should be receiving the child support and the correct child support award, that is important. I'm not disputing that child support is an important obligation and that children should absolutely come first, but we need to make sure that the child support award is going to the appropriate parent. And sometimes the way to do that, because abusers can use the system to work against the victim, sometimes the way to do that is to hire an attorney. And I will also point out that when the litigation is going on, if there's a child support award, there's an arrearage building. It's not saying this person's not going to be responsible for child support. There will be an arrearage building and that money will be owed at some point to one of the parties once the litigation concludes.
Are you all set, Representative Long? Okay. Are there any other questions? Seeing Representative Long, you're good? Seeing none, thank you very much.
Thank you for your time.
And is there anyone else who did sign up ahead of time that would like to testify? Richard Head.
Good morning, Madam Chair and members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We don't have any position on this bill. And normally these are comments that I would make in a work session, but I honestly don't know how work sessions work this year. So I'm just going to raise a couple points which really relate to just the mechanics of how this bill would work. And what the court system's role would be. So if, for example, if there's priority to child support, but a lawyer has been paid by a retainer, how does that impact the retainer? If the costs or payments are charged by the court and child support is an ongoing obligation, how would that work if the first child support payment is made, payment of the costs and fees are made, but then subsequent child support is not made? Does that somehow impact how those fees and costs are being paid, or is there some other obligation? So it's more or less just the mechanics that are unclear in the language of the bill, which I would normally talk through in a work session, but not knowing the process this year, I'm just raising it as questions for the committee to consider this year. Thank you. And by the way, I don't pretend to be an expert in family law and the court process for family law, but just had these concerns. But again, the court system has no position relative to the policies in this bill.
Well, thank you. Are there any questions for Mr. Hood? Seeing none, thank you very much.
Thank you. Thank you for your time today.
Okay, so I don't see any other hands up. So we had Representative Alicia, your hand is up.
Madam Chair, did any of the speakers have written testimony?
Not that I have, unless it's emailed in, but.
No, I have the emailed ones. I'm just double checking. Thank you.
Okay, so we had, let's see. One person opposed, one person neutral, and two from the Senate support. So I'm going to close the hearing on House Bill 541, and then I'm going to give the clerk a minute. Get ready for the hearing on House Bill 228.
I'm ready, Madam Chair.
All right, so I'll open the hearing on House Bill 228, and I will call up Representative Deb DeSimone.
Thank you, Madam Chair. Representative Alicia, can you hear me? Okay. Thank you, Madam Chair, and members of the committee and the public who are listening. House Bill 228 is relative to the calculation of child support in cases where equal or approximately equal parenting time is given to both parents. There seems to be an inequity in that area of the law, and so that's why this bill was brought forward. And I will defer all comments to the constituent who brought this bill to me, Attorney Jay Markell. Thank you, Madam Chair.
Thank you, Representative DeSimone. So you won't be taking questions, you'll be deferring them to Attorney Markell?
That is correct.
Okay, great. All right, so next up, we have Marilyn Mahoney to speak in opposition for 5 minutes.
Thank you, Madam Chair. Hello and good morning. I'm an attorney who has practiced in family law for about 40 years. I did submit a summary of my testimony to the committee by email this morning. In effect, this bill, as well as a bill that you're hearing later today, House Bill 161, I believe, both address the issue of what happens for child support when parents have, well, in one bill it's called shared parenting time, and in the other bill it's called equal or approximately equal parenting time. This bill uses the term, I believe, equal or approximately equal, and it refers to any of those cases in which there is, quote, a disparity of income. The two bills that are before the committee conflict in some significant ways. And they also would make a significant change in what the current law is. I think it's important for the committee to keep in mind that every family, every parent, and every parent's economic situation and family situation is different and unique. The concern I have particularly with this bill is that it creates a rebuttable presumption. The rebuttable presumption is really the biggest flaw I believe this bill has, because it in effect would override the existing provisions in New Hampshire law that allows the court or the parties, when they're trying to negotiate a settlement, from being able to take into consideration the various factors. So for example, it is the case, I believe, in most families where one parent is going to be paying for daycare. One parent is going to be buying more clothes. That may not be the same parent. One parent is going to be incurring more of the expenses for a child, say for school supplies or extracurricular activities that that results in, even though they have equal time or approximately equal time, not an equal economic impact. And those factors, which I said are currently allowed to be considered in current law, would be overridden by creating a rebuttable presumption. And I think that using that term is problematic. The formula that's laid out, that is that you do a set off between each party's income, is commonly used now. It's not required by law, but people do it all the time, use it all the time as a kind of a guideline. And it in and of itself, I don't believe is a bad idea. I think the bad idea in this bill is making it a rebuttable presumption. Given that there are these two competing bills, and the other bill is much more complex in terms of the changes it makes to existing law, it would be my suggestion to the committee to perhaps have these both bills referred to an interim study and look at those kinds of changes that would be made to current law and look for a way to equitably and reasonably implement the concept of the formula without shortchanging families that are struggling, in any case, trying to make ends meet with children. That completes my testimony.
Thank you. Are there any questions for Attorney Mahoney? All right, seeing none, thank you very much for your testimony.
Thank you for allowing me to testify.
Up next is Brenda Town, a member of the public to speak in opposition. She's asked for 3 minutes.
Oh, good morning, everybody, and thank you for allowing the testimony today. I wanted to start by saying I'm a grandmother of 4 grandkids. I've gone through the family courts personally. That exposure has led me to become an advocate for parents. I currently lead a couple New Hampshire parents organizations, one with 3,500 followers on Facebook, where we try to help parents navigate their way through family court issues and also to become stronger and better family units. I'm going to be speaking on child support today on multiple calls, but I did want to speak specifically to this issue. For the past 2.5 years, I've worked with both the sponsors, committee members, and the UNH research team that was commissioned to address child support in New Hampshire. So I'm just going to touch quickly on the history of what's led us here today and why this year this Child and Family Law Committee really owes it to the judges and the families to make a directive on how we address this gap in our legislation. So in 2015, HB 378 was introduced. It was a shared parenting bill, but it was transitioned into a study to be commissioned by UNH Carsey School on our entire child support situation here in New Hampshire. In 2018, they concluded their study and they prepared that for review here for this committee. In 2019, UNH came to this committee and presented their results. And unfortunately, there was a significant calculation error in their report on shared parenting that didn't get corrected until January of 2020. UNH's study was exhaustive. It took multiple years and it cost this state $500,000. The study concluded with 3 important recommendations. And one of those recommendations was that we needed a standardized calculation for shared parenting. Complicating the situation is we have 2 Supreme Court cases in the state of New Hampshire that have now taken the discretion of our family court judges away in determining shared child support cases in equitable distribution of child support. In 2018, there was a case, Silva v. Silva, which it was ruled in the state of New Hampshire that the family court judge could not allocate anything different than the child support calculator unless there was a determination that fixed costs were reduced on the obligee's side. So what that did is it prevented a judge from making a call of smoothing out those child support cases where parents were sharing significant time and expenses. This was followed in 2019 with case Anderson v. Anderson in our own New Hampshire Supreme Court, which then basically pushed back the responsibility of determining an equitable child support calculation for parents in the case of shared child support back to this family committee, because there is no legislation that a judge can use to make an equitable determination of child support. So I know that's a lot of language, guys, but I thought it was important you had that history because there's a lot of effort that brought this committee to this point. Last year and the year before, we had a bill that was brought before this committee, HB 362. It is identical to Deb's bill today. It was put out for interim study. The challenges with the bill were that it did.
Mrs. Kim, excuse me. Please refer to the members as Representative DeSimone.
Okay, I'm sorry. Representative DeSimone brought to the committee this bill that is in line with the HB 362 that this committee had reviewed the prior 2 years. HB 362 was put out for interim study and was actually passed by this committee to not bring for a vote because it is missing some critical information. It doesn't define parenting time. It doesn't define approximate or equal parenting time. It doesn't reflect any of the UNH recommendations, and it doesn't cover the spectrum of parenting time other than approximate or equal. So what I would recommend, and what I'm going to recommend today, is that the committee take under consideration HB 161, which is a comprehensive bill that reflects the $500,000 study that the state of New Hampshire has commissioned.
Excuse me. I need you to stay on 228. You can testify to 161 at the next hearing, but I have people to testify on this specific bill.
Okay, I will. I'm sorry, Deb. Sorry, Representative Rice. Chair Rice. I will try to stay on task. So my issues with the bill are not that, in fact, we are addressing the shortcoming in our legislation, but that unfortunately it is falls short in the areas that were identified in last session, preventing us from moving forward with this bill to the floor for a vote. Thank you very much.
Are there any questions for Ms. Town? Seeing none, thank you very much. Up next is Erin Justina to speak in support. She's requested 2 minutes.
Madam Chair, thank you. I actually need to correct that. We are signing in opposition to this bill. And I will just say that we agree with Marilyn Mahoney in referring this bill to interim study. Thank you. And I apologize for the inconvenience.
No problem. Thank you so much. Are there any questions for Ms. Justina? Okay, seeing none. Thank you. And up next is Attorney Jay Markle, and he put down 0 minutes, but I'm going to let you have a few. Okay.
Oh, okay. Thank you. I had signed in, I thought, for 5 minutes. Briefly, to address this bill, what it does is that I had also submitted some written information on it. Basically, what this bill does is it addresses disparity of income issues. The offset method, as was previously testified to, is a very well accepted way of equalizing the child support between the parties' income. So it's pretty easy to understand. It's simple to calculate. The holes in the law that it tries to address are the draconian results of Silva, which was previously alluded to. Contrary to what I think I heard before, there is absolutely nothing in this bill that in any way limits the balance of RSA 458C5 because it leaves intact and provides for additional flexibility, additional arguments to be made as to why a child support should be up or down. The presumptive order means that it's a rebuttable presumption. Rebuttable presumptions exist fairly all over the place in law. And what this does is that in essence, it allows courts to craft individual solutions to the problems that come in for of it in terms of determining child support. So the calculations are real simple. It's done as in the first instance, as if parent A pays parent B. Then if parent B were to pay parent A, then take the difference in the support order, and the difference in the support order in the first instance goes to the lower income parent as the child support. That's presumptive. Now, all the other side really has to do is just look at the balance of the statute because it retains all of the virtues of the existing statute. It retains RSA 458C5, adjustments to the applications of the guidelines under special circumstances. So what it does, and contrary to the representations I heard, is gives enormous flexibility to a court to be able to craft individual solutions to a problem. Nobody gets painted into a corner. It allows the court to consider the parenting schedule. It does not, and I think it's pretty well understood what equal or approximately equal parenting time is. It should not be micromanaged. Parties are free to argue their cases as to whether or not they actually do have equal or approximately equal parenting time. The courts can figure out what that is. That can be a variety of circumstances. It can be 1 week with one parent, 1 week with another parent. That can be a shared residential program, or it can be any number of days in between as the parties allocate. Remember, this is not one size fits all. This is designed so that the courts have flexibility to stay within the guidelines and create individual orders that are fair. And once again, the person who spoke before said the Silva case presented, as I pointed out in my written testimony, presents draconian options where they're simply not necessary. The Anderson case, as I remember, presented something similar to this to the New Hampshire Supreme Court, and the New Hampshire Supreme Court said, your argument is not with us, it's with the legislature. So this is entirely appropriate. In addition to which, Massachusetts below tried using percentage-based formulas. They found out that in their situation on a 6-year study, that it simply wasn't workable. And basically what this bill does is solve the problems. It provides predictable results. It also has the regular checks to make sure that the child support order is adequate. And that's why that language stays in there. It changes very little, but just what it does is solve a problem. And it does that rather effectively using well-accepted means. Thanks for your time. I'd be happy to answer any questions.
Great, thank you very much. Representative Altschiller. She's trying.
Thank you. It takes about 4 clicks to get unmuted. So
Okay.
thanks for your patience and thank you for taking my question. I'm looking at this legislation and it is an entirely new paragraph to be added into statute. And the part that I'm struggling with, and I need some clarification because I just don't understand this, is lines 10 through 12.
Okay.
So the amount of child support payment shall then be calculated according to the guidelines as if the higher income party were to pay the lower income party, and then calculated as if the lower income party were to pay the higher income party. So that just, in my experience, and I will admit it's limited, that's not a thing. So when one party is at a significant income disparity to the other one, we don't make that calculation. And so to insert that seems to be creating a formula that's based on an impossibility. So I'm really confused about this.
Okay, glad to, good question, happy to answer it. What happens is that, okay, let me start off by saying that neither the legislation, present legislation, nor Silva actually defined what a disparity of income was. So to trigger a full guidelines order. So was that a difference of $100 a month, $1,000 a month, $2,000, $3,000, $4,000 a month? It's unclear. And the present legislation doesn't do that, okay? Now, as to the child support calculation, it would go like this. When I say parent A and parent B, so one parent, let's say for the sake of argument, makes $5,000 a month and the other one makes $2,000 a month, and there's a $3,000 disparity. So the parent making $5,000 a month, the calculation is the $5,000 parent, okay, does a calculation as if the $5,000 parent were to pay the $2,000 parent. The $2,000 parent then makes the calculation as if the $2,000 parent were to pay the $5,000 parent. The difference between those two numbers, okay, you take the lower number, subtract it from the higher number, okay, that difference goes to the lower income parent, okay? And that's a presumptive order. Now, the rest of the statute stays completely in place, and then the court is free to do a check. And not only that, the other party is free to argue that that is not a correct order based on the entire statute, okay? Absolutely very little changes. What it does is that it gives you predictability. So for example, if a child support order were to result from higher to lower, would be $200 a month from the higher income parent and the lower income parent would have paid the higher income parent $100 a month. The difference is $100. That $100 goes to the lower income parent. Now, if for any reason that order is not deemed adequate, okay, that party is free to argue to the court, but judge, it's not adequate, and I'm going to ask you to take into considerations the following adjustments that we need to make. It's all right there in the statute, and the parties are free to argue. All it does is it gives you a jumping off point, and then the parties are free. And it's going to solve a big problem because I think, as Attorney Mahoney indicated, it's been in common use. All this does not reinvent anything. This is not new or novel. In point of fact, I'm referring to what I consider to be the Bible in this particular case, which is Child Support Guidelines and Application by Laura Morgan, second edition from 2020, who's probably one of the leading authorities in the United States on child support. She recognizes, and has been widely recognizes, that the offset method is what's being used, okay, to determine a lot of child support calculations. So this is nothing new. It's generally well accepted. Once again, I would refer to people who did a 6-year study. The Massachusetts court system did a 6-year study, and they concluded in their 2018 guidelines that percentages don't work, and they use a variation of the same thing. And we know what shared residential responsibility is. You know, if it's 6 days or approximately equal, courts can make that determination along with the parties. I hope I answered your question.
May I follow up,
Of
Madam?
course.
Follow up.
Thank you. So I'm trying to keep up with you here, and my question now is, do you think that this, as it's written here, can be used to put a price tag on parenting time?
I'm not sure I understand what you mean, madam.
Would parenting time be given a denomination of value in the child support?
Well, the idea
Is there a financial incentive?
Okay, well, this kind of takes the financial incentive out of it. This is the whole point, because right now what you have is child support driving the parenting plan and people fighting over this. What this does is this frees parents to be parents and makes child support has to be adequate, but it also should be fair and easy to determine and transparent. And that's what this is.
Are you all set, Representative Batchelor?
Yeah, I think one of the things that's kind of sticking at me is the, you know, as this is written, it assumes that the parents are in agreement. And if there is, you know, if they're not in agreement, I guess my question would be in line 4, where, like, how would a pro se parent know that they have to know that there's a rebuttable presumption and know what they have to do to refute that? Particularly if that's not, you know, an agreeable separation.
Well, once again, parties, okay, well, the law is published online, and I respectfully point out that parties really should be reading, even pro se's, should be looking at the law online to determine what their rights and obligations are. Now, obviously, that may or may not happen, okay? But, you know, they're certainly free to look up a lot of sources. It's there. The law is there for everyone to see. And one of the virtues of this is that it's easy to understand. Let's put it this way. I can understand how it would be foreign if you're not used to working with it, okay? And it would confuse and let's put it this way, I can understand that. But when you're used to working with it and the judges understand it and the parties can look at that and say, well, wait a minute, I make this, she makes that. She makes this, he makes this, I make that. So this is what my child support payment would be. Okay, now I'm going to ask for more money because the order wouldn't be adequate from my point of view, whether you're whoever you are. Parenting time, I don't know that you can quantify it, but it involves mutual obligation. The other thing is that it frees parents to be able to focus on their kids and involve in parenting and develop a parenting plan rather than fighting over the draconian results of what would be a presumptively unfair child support order.
Great, thank you. Representative Long.
Thank you, Madam Chair. Thank you, Attorney Markle. Just to say, when you answer my question, with all due respect, I get it after a couple of sentences. When you get into the 5 or 6, I lose my whole thought. So it would help me if you would just be precise. So with respect to pro se, do you believe this would be more complicated for them to figure out?
I think it would be less complicated than a competing bill.
Okay. And also on if both parties came and agreed to everything, is that still eligible if this became law?
Yes, it is. In fact, what it does is it allows, for example, it allows parties to argue their cases individually. This paints nobody into a corner. Okay. So, for example, I'll give you some scenarios.
I don't need the scenarios. Because I'm going to get lost.
Oh, okay.
If I could follow up, Madam Speaker.
Follow up.
Thank you. So you're talking about the parties arguing, and I'm talking about, my question was on if the two parties agree on everything, who's getting paid what, who's paying for the dance lessons, they agree on everything. Does this still have to be implied? Do they still have to go through this calculation? Or do they still, go ahead.
They probably do, but let me explain. That's just a function of child support worksheets. That's all, because every child support case has to be accompanied by child support worksheets.
Okay.
And then the court is free to make its individual findings.
Okay. Okay, so one more, if I may.
Of course.
Thank you. Thank you, Attorney Markle. I'm trying to look at the contentious litigations and how this very hard calculation in my mind. I mean, I know it's easy in your mind, but in mine it's not. How this will impact, I'm looking for, you don't see an opportunity where there's an incentive to not be forthcoming on some issues when you're doing a calculation like this, because let's see, at my real $5,000 a month salary, I pay this, but at my $4,500 salary, I'll pay X. So do you see incentives to circumventing where there's more angles to circumvent this calculation process?
Oh, okay, I see. Well, that's a common problem, and it has understating income, becoming unemployed, imputation of incomes are problems common to many divorce and parenting cases across the board. This would not stand out one way or the other. There are always questions with financial affidavits and whether or not parties are being forthright as to their income. I don't think this has effect one way or the other.
Okay, thank you, Madam Chair.
Thank you very much. And also, can I just ask everyone to slow down a little bit when they're talking, because the clerk is trying to keep up with everything. Representative Lewicki, you have a question?
Yes, I do, Madam Chair. Thank you. For me, it is difficult to understand Section 3B. I think since I don't have the background, I fortunately have never been involved in the child support situation. And if someone, Attorney Markle perhaps, could provide us with some background and also turn the attempt there to do basically put down arithmetic in text. I think if it were presented offline, as the arithmetic, it would be easier for me to understand. Thank you.
Yes, so so Attorney Markel, my thought was perhaps you could put together some sort of a diagram that explains parent A, parent B, 2,000, 3,000, and how it intersects and meets and comes up with something. If you could set up some sort of a diagram for us and email us or something, I think that would be very helpful.
Be happy to do it. Sure, I can give you some examples of how the calculation works. Is that what is that what I'm hearing is what you're looking for?
Yes, but on paper.
Okay, I can do that.
Okay, great. Thank you very much. Will that?
Yes, thank you, Madam Chair. Thank
Okay.
you, Attorney Markle. That's
Is there
exactly
any
what I'm
further
looking for.
questions? Seeing none, thank you, Attorney Markel.
Thank you.
Okay, that's the last of the people on my list, and now I have two people who want to speak and the attendees, and you're going to have to be brief because we are now over time. So, Bill Woodbury. Where'd he go? Mr. Woodbury, can you unmute?
Yes, Madam Chair. Can you hear me now?
Yes, thank you.
Thank you, and I'm sorry I didn't sign up earlier. I will be very brief. My name is Bill Woodbury. I am an attorney practicing in the city of Laconia. I practice primarily in family law, but also in other areas. And I'm also the legislative chair for the New Hampshire Association for Justice. And we're speaking in opposition to this bill. I would echo the thoughts of Attorney Mahoney with respect to study of both 228 and 161. And I would disagree with Attorney Markle respectfully that this bill would take the financial incentive out of this. We oppose because we believe, and I would echo the thoughts of Representative Altschiller, that anytime you try and fold into the calculation the parenting time, then you create an incentive for people to fight for more parenting time solely because it will potentially cost them less money. So I was asked to be brief, and I will be, but that is our position in this, that this, should never be folded into the child support calculation. It creates an inappropriate incentive. I'll take any questions people may have.
Thank you, Attorney Woodbury. I have a quick question, but would you agree that right now there's financial incentive that people go to bat fighting left and right because they don't want to pay child support, or they feel they're paying too much, so they tend to drag out the court cases for longer periods of time to try to get the more parenting time because they think in their mind that it's going to lower their child support?
Representative Rice, it is a battle that I fight on a daily basis. However, right now, there's no incentive for someone to say, I want more time because I'll pay less. And that is why these bills shouldn't pass.
Okay, thank you. Representative Altschiller?
Okay, I only took 2 clicks to unmute this time. Thank you. Thank you for taking my question, Attorney Woodbury. So here on the Seacoast, I want to give you an example and see if I'm understanding what this legislation will do. We've actually had a very public case where a father was physically abusive to the mother and was caught being physically abusive and subsequently charged with domestic violence. Mom leaves, right? Is able to separate from parent, takes kids with her. She's employed. She has a job and she's able to go back to her job. Dad loses the job because his abuse is now known and there is no longer trust in him to do his job that he had because it required public trust. and there's bad press around it because trying to kill your wife doesn't really, do a lot for your job prospects. So now he's underemployed. Where's the incentive for him to get another kind of work or to get work at all while his wife is employed and supporting those children? What's the incentive under this statute, if it were to come to pass, for him to go forward and actually get work?
I mean, in that particular situation, I mean, there's a number of things occurring there, and there's a number of motivations that he has to continue kind of maintaining this, this negative behavior. But the problem specifically here is that a person who is voluntarily underemployed, voluntarily unemployed, or who simply does not want to, pay more money, has an incentive to argue that it's in the best interest of the children to have equal parenting time between the parents, where that incentive does not exist now. Everything is based on income, and the reason being is that child support, the specific intent of child support, is to equilibrate the economic experience between the households. And in the situation that you mentioned, and in a myriad of other situations, an individual who is looking to game the system by creating, in this case, a rebuttable presumption that equal parenting time should reduce their child support obligation, that is the problem we see with this. And in 161, we would echo the comments of Attorney Mahoney that this should go to study.
Thank you. Are there any further questions? Being none, thank you, Attorney Woodbury.
Thank you.
I see one more person with their hand raised in the attendees. Kristen, we're almost out of time on this, so I can give you 2 minutes, and then to the John that raised his hand, I can give you 2 minutes, but we are out of time on this hearing. So Kristen Smith.
Hi, thank you for taking my comment. I'm Kristen Smith. Can you hear me? Yeah. I'm Kristen Smith. I was one of the co-authors of the child support report. So I would just encourage you to take a look at the third recommendation, which lays out the shared parenting proposal. I'm neutral on this bill. I just want that to be out there. And if you want some examples of how different earnings and different scenarios of parenting time would influence the proposed changes in this bill, that's a good place for you to look. The other thing that I would just point out is that the bill does not stipulate how parenting time will be calculated. So when I read it, I did not see whether this would be measured in overnights or whether this would be measured in time spent with children. So that is an oversight in the bill, as well as we also recommended that there needs to be exceptions when parenting time is addressed to ensure appropriate safeguards are included, particularly in cases with intimate partner violence, to guarantee safety for the child and the abused parent. So that sort of comes back to what Representative Altshuler was just talking about. I'm happy to meet with committee members if you have questions about the report. Thank you.
Are there any questions for Ms. Smith? All right, seeing none, thank you very much. Next is John. Just John, you have 2 minutes.
Yes, I just want to point out, I don't see a threshold for parenting time in this bill. And I believe it's based on the UNH study, which did have a threshold of 30%. And I'm wondering why there's no threshold in this bill.
So
secondly,
why? Okay, but you can't ask questions of
okay.
Sorry.
Okay. Last point. I would recommend if this is passed that it would start on April 1st, 2022. That would coincide with a major update to child support that the division performs on April 1st every year. So that would eliminate two major changes they would have to do.
Okay. Are there any questions? John, can we get your last name for the record, please? You need to unmute.
I've had trouble with my connection, so I haven't heard the entire meeting.
We need your last name for the record.
Yes, it's ADLAS. V is in victory.
Okay, thank you.
ADLAS.
Are there any questions for John? Seeing none, thank you very much. And that's, is he gonna take the sound down? All right, so that's all we have for testimony. So we had 2 signed in support, 6 in opposition, and 4 that were neutral. And so I'm closing the hearing on House Bill 228. I'm going to give the clerk a minute to get ready for House Bill 161.
Thank you, Madam Chair.
Okay. So, Representative Yokella, would you like to introduce your bill? I don't have you signed up on here. Representative Yokella?
Yes, thank you.
Okay.
I'm sorry I'm not signed up. I'm not sure how that happened.
Keep in mind, we're running a little behind.
Okay.
Go ahead.
Thank you, Madam Chairman and members of the committee. I'm here to present HB 161. This bill was worked on for a significant amount of time last session as response to the 2018 Child Support Guidelines Review. And those guidelines recommended that we do 3 things. It recommended that the New Hampshire Child Support Guidelines table be updated. It recommended that we increase the self-support reserve from 115% to 120 of the national or of the federal poverty line. And it suggested that we enact changes to the guidelines to address shared parenting. And those 3 things are what this bill does. The simplest thing is just changing the 115 to 120 for the federal poverty line. The child support percentages recommended by the review are in the actual report, and the only addition made to that was for a 4th child. It only did percentages up to 3 children, and the calculation was kind of followed out to the 4th child, and that is included in the legislation. And then comes the recommendation that we address shared parenting time. And it recommended that we, as you heard earlier, it recommended that we set a floor for what is shared parenting time so that the courts will know. And it recommended 30%. And that's what this bill does. It also recommended that when you have two households parenting, that the costs of maintaining those households is higher than one household. And so it recommended that you multiply the amount of child support, or the amount required to support the child, to be multiplied by 1.5%. And that recommendation is also added to the bill. And it also wanted the change for child support to be based on how much time was given. So if you have 50%, you'll get more credit towards supporting your child, because when they're with your with you, then you are spending that money to support the child. You get more credit if you have 50% than if you had 40, and you get more if you have 40 than if you have 30. Whereas, and so those calculations are all included in this bill. And I wanted to help give an example of that by, let's see, I wanted to share some information that you guys were seeing in.
I don't think we have the ability to share on the screen. If there's some.
I'm pretty sure we do. Is this sharing?
Yes.
Can you see this? Great. So can you see this scenario 1 on your screen? Can you see this?
I can see
okay,
it.
Great.
Representative Yokela, I have to check. I'm not sure that we were allowing things to be shared on the screen, because only panelists can do it, but the members of the public can't.
Yeah, well, this is an important part of the aspect, so that we address the issues of people being able to understand how this is. It was just recommended that we share in the last bill some examples so that people would be able to follow the logic. So I think this is important that we do be able to see this. So in this first scenario, the people have the same amount of income, and the percentage of the child support amount is based on that income. And then there is a credit, and then that amount is multiplied, because this is a shared parenting formula, or a shared parenting situation. It's multiplied by the 1.5%, and then the person gets a credit for the amount of time. So in this situation, they both earn the same amount. They both have the child for the same amount of time. And so there's no obligation required. Whereas in scenario 2, the obligor earns more than the obligee, and the amount of parenting time is the same, but the obligation is where the obligee, or the obligor, needs to pay the obligee an amount to offset based on the amount of money the difference of the money. The obligor in this case earns 59%, whereas the obligee earns 41% of the household income. And so in scenario 3, there's a difference of the credit. There's a difference in the earning from the obligee and the obligor, and there's a difference in the parenting time. It's only 40% instead of 50%. And so you can see that when you multiply the total amount, the adjusted amount for shared child support obligation you multiply that by 40%, and that is the credit that that person gets towards their obligation. And so there is an amount reflective of both the difference in income and obviously the difference in parenting time. And so that is all that I wanted to show. You guys have a copy of those slides in your email. And so I just wanted to give that information so that you would be able to make a decision on this issue. I'm happy. So another thing, one last thing that I wanted to point out was that in the recommendations from the 2018 child support guidelines, I think that it's important to point out that the recommendation is that we adopt all of the recommendations of the report and not just pick and choose, because that can have some negative impacts. And so this bill actually tries to address all the recommendations and implement them. I thank you and happy to take questions.
Okay, Representative Altshuler.
Oh. I'm sorry, I think I hadn't taken my hand down from the last time. Sorry.
Okay. Are there any questions? Representative Belanger.
Thank you, Madam Chair, and thank you, Representative Yokela, for your introduction in this bill. I guess being new, I'm a little kind of confused between 161 and 228. Are they? It sounds like you're addressing the parenting time, but as is 228. So can you just kind of?
Yes, I'm happy to help. So 228, the language from that came out before the report for the review guidelines. And so it does not incorporate the recommendations. It just identified one of the problems in our child support system and does not really address the entire thing, which 161 is trying to do, and is trying to implement those changes. And so it's completely apples and oranges between the two, even though it's
So
partially trying to address the same.
Would take up in work session.
Okay.
Okay. So that we can distinguish the two. Representative Long.
Thank you, Madam Chair. Thank you, Representative. 30% or more of the time. Is that 2 nights a week? 7 days? What do you know what that is? How much time or how many overnights that is?
So it would be more, it's in between, it's more than 2, but less than 3. So, if you had,
Okay.
2 nights a week and then some other, rotating day or something.
7 nights is 100%.
Right.
Okay, thank you. And one other question, the 1.5 calculation, how did that come about?
Well, it's recommended in the child support guidelines. It came.
1.5, okay.
Yeah,
Okay,
yeah, it's recommended.
that's good.
Okay.
And then my final question, if I may, Madam Chair, now that we're putting this into statute.
Can you just slow down?
What's that?
Can you just slow down a little bit? The questions are coming really fast.
Okay. So if you want so I'm asking if the fact that you put these calculations in at the end of the year, can I get a reimbursement because I was calculated for 30, but when I did my records, it was actually 45?
So this would be based on the plan that you create. So it would be, the plan would be encompassing the whole year. Like maybe you have weekends and holidays and stuff like that. That would be incorporated for the whole year. And so if there was a change, you would need to file for an adjustment and prove that the change is, permanent, et cetera, et cetera. It wouldn't be just, a rebate process. Yeah.
Thank you.
Okay, any other questions for Representative Yokella? Representative Belanger.
So, thank you, Madam Chair. Representative Yokella, if 100% is identified, can you explain how 100% of parenting time would be identified if someone is visiting with their kids 7 days a week? Are we referring to percentages of days in 1 week, or the number of days per month that they're visiting with the child?
Neither. It would be based on, so the calculation is based on overnights, which was recommended inside the guidelines. And the plan would be able to encompass an entire year. So you would say every other weekend, 3 weeks in the summer, maybe holidays, et cetera, et cetera. And so all of that would be stipulated, and you would find that calculation via the whole year.
Thank you.
Okay, I don't see any other questions. Thank you very much, Representative Yokella.
Thank you.
Up next is Michael Bear, who is asking for 60 minutes, and I cannot give you 60 minutes. I can give you 5 minutes. Everyone else has asked for 5 minutes, 3 minutes, and 2 minutes, and we're already way behind. So I can give you 5 minutes, but I cannot give you an hour. This hearing wasn't even scheduled for an hour. So you just need to unmute. Mr. Bear? Thank you. Mr. Bear, are you there? All right, we're going to have to come back until he can get unmuted. So we'll go to Christopher Cianci, who has requested 5 minutes. And sticking to it. You have to unmute, Mr. Cianci. Can you hear us? Yes, you have 5 minutes.
Hello, can you hear me?
Yes, you have 5 minutes.
All right, so I would just like to say that this bill should be passed, and I personally experienced having to pay the full child support payment when I had shared parenting, and it really just negatively impacted my parenting time with the kids. And it took a long time for it to get corrected, but I would just say this is something that would prevent other people the hardship that we went through.
Is there any questions for Mr. Cianci? Seeing none, thank you very much. Mr. Bear, are you there? Can you unmute yet? Mr. Bear, can you unmute yet? Okay, we'll go on to Attorney Marilyn Mahoney, who's to speak in opposition to the bill.
Good morning again. Thank you very much for allowing me to testify. I am testifying in opposition to this bill, but only for there are certain specific provisions that are very concerning. The devil is in the details, as they say. And so as I look at this bill, the biggest concern, one of the biggest concerns I have is in providing a specific definition for shared parenting. The definition, this is right about the fourth line from the beginning of the text of the bill, is that it is where the child overnights with each parent 30% or more of the time. My first concern is by counting shared parenting as overnights. It doesn't take much imagination to realize that over at night is the least expensive time to have a child with you. The expenses arise during the day, and taking children to their activities and providing them with food. Overnights doesn't do that. So I think using the calculation of overnights is deeply flawed. The deeper concern I have is with the 30%. 30% of anything, it's certainly not shared. If I have a pie and I eat 2/3 of it and only leave you with less than 1/3, we've shared it, but I don't think we've done it in a way that is in any way close to being equal or approximately equal. Also, the minute that you start to use a specific percentage, you drive up the conflict in the parenting end of things. And suddenly the issue of who has the child an additional overnight becomes a huge factor, and you create conflict in the place that you least want it to be. You may solve a problem with child support, but the parenting issues relating to the child suddenly become intensely conflicted. And for all the wrong reasons. It becomes conflicted because of the money and not about what's in the best interest of the child. That phrase doesn't appear anywhere. What is in the best interest of the child doesn't appear anywhere in this bill. With regard to that issue, I think that you should at least remove that. The phrase equal or approximately equal has been recognized and understood without really any confusion, as far as my experience has been, as to what that means. And so you don't need that definition to be replacing what the practice has been for many, many years. The other issue that I have is with the repeal, this is at the end of the bill, a repeal of RSA C51H1. That states that equal or approximately equal parenting residential responsibilities in and of itself shall not eliminate the need for child support and shall not by itself constitute ground for an adjustment. That's crucial language that is referred to all the time, and that language should remain in the statute. It should not be repealed. I have more concerns, but I know the time is short and I don't want to take too much of your time. So I urge the committee to send this as well as 228 to interim study. There's a lot of merit to this bill. As I said, the devil's in those details. Thank you very much.
Thank you. Are there any questions, Representative Law?
Thank you, Madam Chair. So would language like in nothing in this paragraph shall preclude a court from modification of the presumptive child support order such as justice in the best interest of the child may require suffice some of your concerns?
No, not really, because you got to understand that probably 75 to 80%, if not more, of cases settle. And so the arguments and the conflict occurs much earlier than that provision would apply.
Are there any further questions? Okay, seeing none. Thank you very much, Attorney Mahoney.
Thank you.
Up next is Brenda Town, and she has asked for 3 minutes.
Thank you, Chairman, and thank you, members of the committee. I wanted again to speak in support of this bill. As we are looking at this huge gap in our current legislation, we are having parents faced with significant financial hardship. It has been well studied that equal and shared parenting time actually creates the most healthy viable children short of an intact marriage. And what we're finding is that we are, as a state, adopting more and more shared parenting. But unfortunately, our child support orders have not kept pace. And so we end up with one parent, because of the outcome of Silva v. Silva, bearing the entire financial burden of the child support, while the other parent is participating in full parenting responsibility up to as much as 50% of the time, and yet gets no financial relief. In my role as a parent support advocate, I have met parents that are struggling to be able to meet the needs of their kids, because compounding the matter is that our DHHS policies around food stamps, childcare, and all the other state aid that we provide low-income parents did not keep pace with the move to shared parenting. So typically that secondary parent does not have access to those benefits as well. I'd like to point out that HB 161 is a direct reflection of a very deep dive study that was done on behalf of New Hampshire. That study is posted out on our DHHS website and is a reflection of the direction our state was committed to going into as an outcome of that study. And I really appreciate Kristen Smith dialing in today, because she interviewed, along with her research partners, thousands of lawyers, GALs, and judges in order to get the outcome. And there was an outcry by our legal system for standardized calculations, because it takes the mystery out and it drops the level of contention on this very tricky area. And without contention on the front end, we create a better situation for our kids, because parents aren't fighting over this stuff. I'd like to point out this calculation has been in practice in Vermont for over 8 years successfully. This is not something new that we're wading into. And the gaps that we've historically struggled with, which include a lack of definition around what shared parenting is, a lack of definition around this entire calculation, will be remedied with this bill. And many, many parents here in the state will be removed from financial hardship. It's the responsibility of this committee to bring forward legislation and not kick out another round of study, because we've done that since 2005. And we really owe it to our parents here in New Hampshire to reconcile this situation once and for all. And I just speak for those kids who are stuck in the middle and are really looking for us to step it up and match what other states in this country have easily been able to tackle. So again, I'd be glad to answer any questions. And I thank you again for all listening and your participation in this family committee.
Representative Long.
Thank you, Madam Chair. Thank you, Ms. Gold. Great testimony. Now, is Vermont solely on overnight also?
Yes, they use this exact prescription. So when UNH did all of their work through the Carsey School, they looked at best practices. And this was a best practice that they identified that met the gaps that our judges and our lawyers and our GALs came forward with. The only other thing I'd like to add that I didn't include in my testimony is that last year, when we were trying to remedy the HB 362 issue, and it had been recommended to go out to interim study, I had an opportunity to meet with our Title 4D, as well as Judge Ashley, the assistant administrative judge in our family courts. And both of them endorsed getting to the standardized calculation, because it will preclude a lot of the front end acrimony that affects parenting. So again, thank you guys very much.
Are there any further questions from this town? Representative Belanger.
Thank you, Madam Chair. Ms. Town, just to kind of confirm, are you saying that the judicial system supports this bill? I didn't quite.
We did not have the exact draft of this bill in front of them. What I will tell you is that they were very supportive of having a standardized calculation to take the mystery out of shared parenting, which they typically find is an issue between family court judges using their own prescription. It has created a great divide because some judges rule one way, some rule another way, and it creates a challenge. So Judge Ashley was very supportive of getting to the standardized calculation.
Are there any further questions? Seeing none, thank you very much.
Thank you, guys. Have a good day.
Let this hearing go until 11:30. If we're not done by 11:30, I'm going to have to recess it, and we'll have to come back another day to finish. Because I have another hearing that was scheduled for 11:15 that we're already cutting into. So up next is Derek Yates.
He's Derek Yates online system. I only see Derek Champion.
Is there a Derek Yates? If you're there, could you raise your hand, please? Okay, we go on to the next one. Erin Justina.
Madam Chair, we have a Derek Champagne that's unmuted. Is that the person?
I asked Derek Yates to raise his hand. Derek Champagne, are you Derek Yates?
No, ma'am.
Pardon me?
Okay.
No,
He said
ma'am.
no.
Okay, thank you. Erin Justina.
Thank you, Madam Chair. I'll be very brief. I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance, and we are testifying in.
Oh, what happened? You muted, Erin.
Can you hear me now?
Here you are, yep.
Did you hear any of it?
No.
Oh, sorry. Erin Justina, I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. We are testifying in opposition of this bill. I will echo the comments of Attorney Marilyn Mahoney and would recommend that this bill go to interim study. I will just quickly say that when you tie child support to the parenting time, you risk people seeking parenting time only in an effort to reduce their child support obligation, which in an abusive situation can put kids at risk. And thank you for your time.
Are there any questions for Ms. Justina? Representative Long.
Thank you, Madam Chair. Yeah, Ms. Justina, do you know the percentage of cases that are tied in with abuse?
Representative Long, thank you for the question. I don't have an exact percentage off the top of my head. It's certainly data that I can get to you. There's some court information I'm sure that can be shared regarding the percentage of cases involving domestic violence, sexual assault, or stalking.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much.
Thank you for your time.
Up next is Dennis Malloy, an elected official, and he's asked for 2 minutes.
Good, thank you. Yes, I'm Representative Dennis Malloy from Greenland, and this is an example of I'm co-sponsor of this bill, and it's an example of constituent service. You heard earlier from Brenda Town, who is a neighbor, and brought this to my attention, and I met with Representative Yokela and Representative Abrami about this. And also, I wanted to point out that over the past year, another member, I think, of this committee, the Honorable Skip Berrien, helped put some of this together in what you're seeing in this bill. So it's been around a while. It was, again, this is my work on behalf of a constituent that I felt was important to hear. This is at the I'm laying this, Representative Yockel and I are laying this at the feet of the committee to consider and work through. I don't have charts. I don't have the detail that others do. This has not been an experience that I've ever personally had to go through, but I just wanted to come in and say I'm supporting Ms. Town and others on the committee who've worked to bring this forward before. So thank you for your time and hearing my case for this. Thank you.
Thank you. Are there any questions for Representative Malloy? All right, seeing none. Thank you very much, Representative. Up next is Attorney Markle.
Yes, good morning again. Can you hear me?
You have to be very brief, please.
Okay, real brief. The problems that I see with with the proposed bill are that if you want to try to do an overhaul, that's fine. That would go to study. However, just off the top of my head, given the fact that you have about 60 to 70% of the parties and cases are self-represented, I think the calculations may be difficult to follow. One thing the UNH study did not do was examine the practical consequences of its recommendations, not in the copy that I saw. The Massachusetts system had done things like percentages, which other people have already addressed. They're not workable. I don't think they're workable, as was previously mentioned. What they do is they focus on the fighting and the child support, and that drives the attempt on the parenting plan. The final thing I think that was not mentioned was two things. Number one is that you may be opening floodgates with this in terms of pro se's, not understanding this approach to shared parenting, because if you have percentages, I can right now see the modifications, I can see the contempts, and I can see requests for reimbursement because percentages weren't met for a given month, day, or year. And I can see the courts being clogged with this from pro se's. And finally, which also should be recognized, is that I think when you look at the Parenting Rights and Responsibilities Act, I think it's RSA 461A14. I think courts are still free to use child support in a manner which is most conducive to the child's benefit, okay, which is the overriding concern. So that's kind of it in a nutshell. I look forward to further submissions, and I thank the committee for its time.
Are there any questions for Attorney Markell? Seeing none, thank you very much. Is Mr. Baer available yet? Michael Baer? Could you raise your hand if you're there? All right, so I'm going to go with Marissa Chase. Quickly, please.
Good morning. Can you hear me?
Yes.
Okay. Good morning, members of the committee. Thank you for allowing me to testify. My name is Marissa Chase. I'm the executive director for the New Hampshire Association for Justice. Just wanted to briefly echo Attorney Mahoney and Attorney Josina from the New Hampshire Legal Assistance. We share those concerns. There's a phrase that stuck out in my mind I learned from working with attorneys is criminal law brings out the best in people, family law brings out the worst in people. It's a sad reality, and we would be happy to work with the committee if these bills are going to study. Attorney Woodbury had to hop off because he is remotely teaching his son, but wanted to echo his comments from the previous bill on this as well. Thank you.
Thank you. Are there any questions for Ms. Chase? Seeing none, thank you very much. And then the last person testifying is Kristen Smith. You have about 2 minutes, Ms. Smith. You just need to unmute.
Yeah, sorry, it just took me a minute to find. So I just, I'm sorry, when I testified earlier, I thought we were talking about House Bill 161. I came in at 10:30. So the comments that I made for, I guess it was House Bill 228, were in reference to this bill, which is basically having, I do see now that there is, that overnights is in the bill, so I apologize for missing that. But just not having any kind of accommodation.
Oh, what happened? Where'd she go? Ms. Smith, are you there?
I think she may have accidentally got bounced.
Hold on, here she comes. Ms. Smith, are you there? There you go.
Hello?
Yeah, there you
Can you
are.
hear me now?
Yep.
Oh, I apologize. I'm not sure how that went from unmuted to muted. I was just saying that my comments earlier were really in reference to House Bill 161. I didn't realize that you were talking about a different bill, so I apologize for jumping in then. The one thing that I do want to just bring your attention to in the report is that 63% of the child support cases, the judges, when they're working through the child support cases, 63% deviate from the child support guidelines. And so we were asked at UNH to look at the child support system, and we were asked to look at what a feasible shared parenting program would look like. And so we looked into what other states have done and looked at best practices and put forward this proposal. Like I said earlier, I'm neutral on this bill, but the proposal that we put forward, which looks like is well represented in this bill, is based on the research from other states, from what other states are doing. So the one exception that I would like to just bring your attention to is cases with intimate partner violence and domestic abuse do need to have a consideration, and other states are doing that. There's other people who have spoken today who are better equipped to give guidance on what that would look like than I am, but it is a provision that is in other states and would be a really good safeguard for those situations. Again, I'm happy to talk about the report with people who have questions on the report. That's it.
Thank you. Were there any questions for Ms. Smith? All right, seeing none. Thank you very much. And thank you everyone for your testimonies. So we had 31 people sign in support, 6 opposed, and 2 were neutral. And that will close the hearing on House Bill 161. I am now going to give the clerk time to get ready to open House Bill 317. So just let me know when you're ready.
Ready, Madam Chair.
Okay. Okay, so I'm going to open the hearing on House Bill 317. This hearing is only going to go until 12:15. So I would ask that the speakers keep that in mind. Please don't echo other testimony. If you have something new to add, I encourage that. But I would appreciate if we didn't get the same testimony from everyone. And please keep it to your time. And I can't do a 30-minute hearing. It just can't go on that long. So I apologize. So I'm going to call up Representative Al Baldessaro to introduce this bill. Is he there? There he is. I see him. 'Cause. 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 ' Okay, Representative Baldessaro, can you unmute yourself?
Okay, I just did the unmute, finally came up. Thank you. Can you hear me now?
Yeah.
Good morning, Madam Chair and fellow representatives. For the record, I am Representative Al Baldessaro, Rockingham County, District 5, testifying from an undisclosed location. I brought this bill forward, HB 317, to correct a major problem within the state. A few years ago, I brought this bill forward, and we were told by the Supreme Court Justice lobbyists that the state of New Hampshire does not go after veterans' disability. They leave it alone. And so the bill ended up dying, and I agreed with them because when I got a divorce, my disability was not touched. Of course, I got custody of my daughter. I was a single father for a while, so it didn't affect me, but I did bring the federal law into court. Now, we have many veterans in the state of New Hampshire that have called me and complained about they're using their disability. Some it's causing homeless. Some of the cases I'm hearing cause suicide on the veterans on putting them out in the street. We tried to get this corrected last time, and then of course it went into interim study. And some of the veterans that wanted to testify had problems through Zoom on their phones in their car and other stuff there. So I'm hoping there are quite a few that are on this here. Now, let me go where I'm going with this here. This here disability, veterans disability, which I'm a disabled veteran, it affects many, many families. And the reason why it does, male and female have the same problem. So this, and it always is who ends up with the children, because no matter what happens in the courts, somebody's not happy. The federal government for many years came out with the law saying that there is what's called apportionment. And during divorce, that the courts and the individuals are required to write to the VA, and they make the decision on apportionments on how much money will actually go to the dependents. Now, there's different stages in this here, whether you're retired, because if you're retired like myself, then a certain portion of my retirement would go to the ex-wife there or whatever. Same thing, vice versa, disability. In your disability, which is not a marital asset, there's a certain portion in there that is divided to the apportionment that will go to dependents. But my main thing here is to make sure that we correct the formula and tell the judges to comply with federal law and not use their disability money for, child support, and let the VA decide on this per the federal law. And like I said, you're probably going to get some testimony today from male and female who've gone through a divorce. And I know after being married 3 times that sometimes children are used as pawns, and nobody's ever happy with, on how much money that they get. So, and they always want more, and I don't blame them. Veterans want to take care of their children. And that's very important, especially me as a father of 7 children. I understand and paid my dues and educated my children. So I can understand where some veterans are coming from. And we do have our 5% that they have to fight with in order to make sure that they support their children, just like anyone else. But this here is a no-brainer here to make sure that the state of New Hampshire complies with the federal law. And I'm going to stop right there because you're going to get more testimony from the veterans in New Hampshire today. Some are probably homeless, living out of their cars, and other ones have gone through this here and gone to the Supreme Court, and they can explain better to you than what I can. So therefore, I'll stop right now and I'll take whatever questions you have, Madam Chair.
Thank you, Representative Baldessaro. So I have a question. Could you kindly send to the committee the federal law you're talking about?
Yes, it's actually in the bill.
The entire federal
You
portion?
want the entire federal law?
Yeah.
What I can do is Sean Bronstein is going to be speaking. And he probably has the federal law right there in front of him. I'm actually not at my home. I'm in another location. And I could probably try to search for it and send it, but I'm sure Sean has it right at his fingertips.
Okay, thank you.
Thank you. Yeah, and I brought this bill forward on behalf of the many veterans. That's the reason.
Right. Representative Petrino? You gotta unmute, please.
Thank you, Madam Chair. And thank you, Representative, for taking my question. You know, I believe that we all want to support veterans, and I think we all want to support children in need. You know, and when I look at this legislation, it seems that veterans and their children are struggling over the same limited dollars. And personally, I think that is a sad commentary on how we treat veterans and children in need. Do you know of any other proposals or legislation out there by which we can actually increase benefits to veterans rather than to take from their dependent children?
Well, this is a federal issue. You know, that the state really has no law, is silent on it. And the federal law says, you know, it's not a marital asset. I wish there was a better answer there. I know we were fortunate under the last president because it took over 40 years to finally get veterans in New Hampshire where don't have a full service hospital to get treated by the best doctors in the community. You know, and like myself, I use Dana-Farber, Dartmouth, and other for operations that I've had within the last 9 months here, and cancer and throat operations. So, you know, it's a great question. It's something that we have to fight our 2 senators and congressmen to push in the federal law.
Okay, thank you.
Are there any further questions for Representative Baldassaro? Seeing none, thank you very much, Representative.
Thank you, Madam Chair. Have a great day.
You too. Up next is Bjorn Bruckshaw. To speak in support, I can give you 2 minutes. I know you asked for 7, but we've got a lot of people that want to testify. Are you there? Okay.
Madam Chair.
Up next is Attorney Mahoney to speak in opposition. And give you 2 minutes.
Thank you very much. Good morning. I am speaking in opposition to this bill. While I have nothing but complete admiration for our veterans, and I agree with Attorney Long that they should, or Attorney Petrino, I mean Representative Petrino, that they should probably be receiving better benefits than what they are. The fact of the matter is the entire family of a disabled veteran is impacted by their disability. And a veteran receives enhanced benefits because he or she has dependents. There is no basis in any law that says that the disabled veteran doesn't have an obligation to support his family or her family. The confusion, I think, sometimes arises, and it's important for the committee to understand that there is a distinction between treating veterans' disability benefits as an asset and as a source of support. As an asset, the law is very clear. Disability benefits, veterans' disability benefits are not to be included in the marital estate when dividing assets at the time of a divorce. Off limits, no question. But the law is also equally clear that disability benefit is a financial resource to that disabled veteran. If the disabled veteran is of low income, if that disability is the only financial resource he or she has, then that is clearly taken into account in the calculation on the guidelines. A very low income individual has a maximum support obligation of $50 a month. However, many disabled veterans are able to work, but they may not be working as much as they would if they weren't disabled. That impact on that disabled veteran also impacts his or her family. And the veteran disability is there to not only provide financial support to the veteran, but also to his or her dependents. That is very clear and has been clearly stated when this very issue came before the United States Supreme Court in a case of Rose versus Rose. And I can give you the site if you need that. I can look that up for you. But there has been a clear precedent in the law, in the federal law, that veterans' benefits are available for the calculation of that veteran's, I have to remember to say disabled veterans' benefits, not just veterans' benefits, but disabled veterans' benefits are available for calculation in determining a disabled vet's support to his or her family. So I urge the committee to not pass this bill. Thank you very much.
Thank you. Representative Long has a question.
Yeah, thank you, Madam Chair. So, Attorney, so if a disabled veteran was to get a compensation, and I'm looking at the calculations here of $1,200 for a child, if this bill passed, that compensation wouldn't be included?
Correct.
Okay, thank you. I just wanted to confirm that. Thank you.
Are there any further questions for Attorney Mahoney? Seeing none, thank you very much.
Thank you for giving me the time to talk to you today. Good luck.
Next, thanks so much. Up next is Jerica Angelini. Okay, you've got 2 minutes.
Okay, thank you. Good morning. I'm the ex-wife of Sean Bronstein, and it's my understanding that he is one of the authors of this bill. And I just learned about this bill last week, but it appears that he's been working on it for quite some time now. Unfortunately, Sean and I had a very lengthy and contentious divorce process, which took years to complete. It ended with him appealing all the way to the U.S. Supreme Court, which declined to review his appeal. The primary driver behind this appeal process was because he vehemently did not want to pay me the child support that family court granted me. I'm here today to express to you my strong concern and opposition to this bill, and it is my hope it will not be passed. I have nothing but great appreciation and respect for all of our military men and women, especially our disabled veterans, and I feel that they are rightly entitled to the many benefits and programs that are offered to them. In my eyes, the bill in question today does not make sense. Child support is granted for a reason, so there is equity between both of the child's homes. Insinuating that the ex of a disabled veteran should forego child support despite being granted to the ex from a judge feels unethical. For instance, if this bill were to pass, it is likely I would lose my child support entirely, which I rely on to provide for my daughter. Who will make up that difference? In my situation, it has been explained to me I should seek TANF money or other benefits granted by the state, which means the shortfall created by not receiving child support would become a burden of the taxpayers and not the person who helped bring my child into the world. In my case, Sean receives a specific benefit, Social Security survivor's benefit, for my daughter of about $1,000 monthly, and that money is no longer split between the parents when they divorce in New Hampshire. However, when I apply for state benefits through DHHS, they include the entire amount of that $1,000 benefit because they say it follows the child, despite the fact that it has already been calculated in my child support payment from Sean. This means that I qualify for fewer benefits as it is. With passage of HB 317, it would mean none of Sean's income would be considered when calculating child support. Yet $12,000 of income paid to him for our daughter counts against me when applying for benefits. Think of how many people would be impacted drastically by passing HB 317, and also think of who. Anyone who splits custody with a disabled vet and makes less annually than the vet would be negatively impacted. That means at a minimum, the most vulnerable would stand to lose the most. I would be one of those people. I have full-time steady work, and Sean's income as a disabled veteran is more than double what mine is. He lives in the house that we bought together, a large home in a cul-de-sac neighborhood. And by contrast, I live in a small second floor, 2-bedroom apartment. There are already great disparities between our daughter's two homes. Without continued child support, the disparities would increase further and be potentially devastating for my daughter, as I may not be able to afford what little I have. I believe there may be other programs or bills that would benefit disabled veterans without encumbering the taxpayers or hurting those of us single parents trying to raise two small children. If passed, this bill has the ability to potentially negatively impact thousands of children in much the same way as my daughter. Thank you very much for your time today.
Thank you very much. Are there any questions? Seeing none, thank you. Up next is Patrick Donegan. I can give you 2 minutes. Mr. Don.
Thank you, Madam Chair. I will try to be very, very brief then.
Representative, hold on. I wasn't calling you.
I was just asked to unmute.
Patrick Donegan.
Not you.
Okay, he's not here. Go ahead, Representative Graham.
Thank you, Madam Chair. For the record, I am Representative John Graham, and I represent Hillsborough District 7, which is the town of Bedford. As a military veteran and one who receives disability compensation from the VA, I oppose this bill. Let's begin by looking at what veterans disability compensation is. It is a monetary payment for injuries suffered as a result of military service. Depending upon the severity, the VA assigns a rating in 10% increments from 10 to 100%. Each of these has a different monetary value, and in my written testimony, I did provide a breakout of what those were at each of the levels. But at no matter which level, the payment is exempt from federal income tax. Thus, at 100% level, the veteran will be receiving over $3,000 a month, and it is tax-free. And at that level, the veteran is eligible to have all of his medical expenses, including dental, provided by the VA. And as shown at the tables at the end, for each eligible child, the veteran receives an additional amount of money. To Representative Long's comment earlier on that one chart where it shows, for example, $1,200, that is not all just for the child. It is part of the overall package. I would also like to point out that there is a problem in paragraph 2 of the bill, specifically a statement, unless the veteran has waived a portion of retirement pay in order to receive such compensation. This refers to an ongoing policy that reduces a service member's retirement pay dollar for dollar if he receives the VA disability pay. Thus, my disability of $400 a month comes directly out of my retirement pay. However, the law was recently changed that if you're 50% or more, which are the higher levels that we're talking about, you receive both your military retirement pay and the full compensation from the VA. But what I'd like to stress here is that the higher the VA ratings, we're potentially talking thousands a month. And as a veteran, and as Representative Baldessaro said earlier, we all want to support our children. I think that we ought to continue along the path that we currently have where it is considered. I know that one of the previous speakers mentioned Rose versus Rose under the Supreme Court. I did provide you all with the synopsis of that, and I would ask that you read that before making any judgments. With that, I hope I kept it under 2 minutes, Madam Chair. And
A little long, but you know.
Well.
Are there any questions for Representative Graham? Representative Altshuler.
I do not. Thank you very much, Representative Graham. I do not have a question for him. I just wanted to let you know I'm getting a message from Representative Horrigan that he's in the waiting room and would like to testify as well.
Yep, I'm going down the list.
Thank you.
Thank you. So up next we have John Jett to speak in support. Mr. Jett, you have 2 minutes. You need to unmute, please. See ya. Mr. Jett, can you unmute, please? Mr. Jett, are you there? Okay. We'll come back to Mr. Jett. On to Christopher Cianci.
Yeah. No, on my list.
You don't see him? I thought I saw him. Cianci. Could have sworn I saw him before.
Was before.
He was before, wasn't he? You don't see him now. Okay, so next we'll go to Claire Lord.
Claire. I don't see her.
Okay, let me see. Mr. Jett, can you unmute yet? Okay, next will be Representative Horrigan.
Oh, thank you very much, Mr. Chair. Can you hear me now? And
Yes,
thank
but
you
I'm
for your patience.
not Mr.
Madam Chair, yes, oh, definitely not. That was like that was like the biggest misstatement ever. Anyway, thank you very much, Madam Chair. And actually, Miss Angelini and Attorney Mahoney and John Graham made a lot of the same points I made in my written testimony, or they did them a lot more eloquently than I could. And just as probably has already been noticed, this is an exact repeat of HB 1716, which came up last year. It was one of the first all virtual bills. The hearing executive session took place entirely on Zoom, but it never got a floor vote. You know, there's some strange stuff happened on the floor, but it probably could have been, and it would have just been an interim study bill anyway. And it was expired by the court case of Sean Braunstein and Jessica Braunstein, who's the same person as Jerica Angelini, who you just heard from a few minutes ago. And I could provide a copy of the court case in case you need it. So he lost that case, and Miss Angelini, well, nobody ever wins a family law case, but she was on the prevailing side, Supreme Court, and went over the facts. We've already covered the facts of the case. Mr. Brownstein and some of the other witnesses in the previous case put some child support worksheets in the permanent bill file, and I looked at those. I actually feel a bit uncomfortable that there's some identifying information that wasn't redacted from all the sheets. In Mr. Braunstein's case, he blanked out his daughter's name, but not her birth date. But so that's something we'll have to think about, especially now that the bill files are like more accessible than they used to be. He argued that his veterans' disabilities benefits should have been left out of the child support calculations. I'm of the opinion, as is the Supreme Court and others, that they should be included. In fact, the disability program specifically supports not just the veteran himself or herself, but the families as well, and also, so like, and child support, you are supporting a family member. You are, and then there's us in Baldessaro. I'm more talking about last time, but more so this time, he argues bill victimizes veterans, but actually veterans are both sides of the child support equation. There's many, especially female veterans, who are in fact receiving child support and deserve to receive child support. And even though veterans do have a higher incident of mental health issues, they don't necessarily in other ways they actually do better than most members of society, simply because we have a volunteer military with high standards for who gets in, and then then also military service. You learn a lot from that. Although I myself, I'm neither a veteran nor have I been through a child custody case. So one divorce I went through, we had no children or anything much to fight about. But so anyway, I'm in opposition to the bill, and the federal law in question, I believe, is 45 CFR paragraph 302.56, and there's also a reference to that in the bill. And also, if you get a copy of Braunstein versus Braunstein decision that mentioned it there, the Supreme Court, it was a rather scathing decision. So they cited many precedents. This is anyway, the veteran disabilities, get back to the main point, the veteran disabilities are earnings and income, so they are something that the parent.
You to wrap it up, Representative.
Yeah. Okay. So anyway, I'm opposed to this bill. I think the federal law actually requires us to count those disability benefits, because it says all earnings and income, and disabilities benefits are income. And also, I think I probably forgot to formally state for the record, I'm Resident Timothy Horrigan. I represent Stratford County District 6, Durham and Madbury, and I'm in opposition to this bill. And I did send in some written testimony, and I'd be happy to send in a copy of the Braunstein case in case you don't get it from some other source. And so that's it. I mean, I'd be happy to ask any questions, but you probably want to move on and hear from the other witnesses. So,
Are there any questions for Representative Horrigan? Seeing none. Thank you very much, Representative.
Okay. Yeah, thank you. And it was a little anticlimactic, but thanks.
Thank you. Up next, we will go to Christopher Cianci.
Hi, everybody. My name is Christopher Cianci, and I am a disabled veteran, and I just think this bill needs to be passed. It's important that it is passed. Veterans who are disabled receive benefits, and it's up to the VA what benefit amount that may or may not be. And they've issued the IM 9803, which is the apportionment process for state courts to follow. And it's just important that that process is followed so that benefits that veterans receive are accurately distributed. And that's what that process has been set up for, is for the benefits to go directly from the VA to whatever beneficiary is receiving the benefit. And so I just think that this bill is important to pass. And that's all I have to say today.
Okay, thank you. Are there any questions for Mr. Cianci? All right, seeing none. Thank you very much. Okay, Mr. Jett, are you able to unmute yet? Because I see you there. Okay, next we'll go to Brenda Town, who has requested 3 minutes.
Hi, can you hear me?
Yes.
Okay, thank you very much. I'm here today, again, just to speak in support of this bill. In my role as a parent advocate, I had my first face-to-face session with parents of New Hampshire. 40 parents showed up, and in the course of meeting them all, 20 of them I recognized were homeless. And of the homeless population, 18 of them were veterans. When I dug into this issue, what I found is that they were disabled veterans and had had their child support taken from their disability pay, which was the sole source of their income. I want to say that veterans do, in fact, want to support their children, and these veterans did. Unfortunately, the compensation that the VA gives a veteran is relatively small versus the child support calculation that the state of New Hampshire grants. For instance, in one case that I'm familiar with, the state gave $39 a child for 4 children. Sorry, that was the Veterans Administration gave that to the parent, a total of $130. And the state removed $1,200 from the veteran's disability, leaving him incapable of supporting himself. With that being said, there is a very discrete process associated for veterans' disability to be granted to the obligee parent. And that is tied to what the Secretary of the Veteran Administration has put in place. It's per USC 511. And what should happen is the state of New Hampshire has no visibility into the issues that a suffering veteran is dealing with. He could be dealing with huge medical costs, prescriptions, all kinds of other expenses in order to be able to maintain his health because this compensation is granted because of injury. What the Veterans Administration does is it offers an apportionment process. And what we are asking the state of New Hampshire to do is follow federal law. It is the federal law that a parent approach the Veterans Administration and follow the apportionment process, at which time the VA will allocate those funds to the parent. It is not in the state's purview to issue these funds. So I just wanted to flag that to you guys. I know that USC 511 will be provided to you. And it is my hope that we have Carson Tucker on the phone, who is an attorney who just won a Supreme Court case in another state, prevailing over the fact that veterans' disability compensation should not be included in a state's child support calculations. Thank you very much.
Thank you. Are there any questions for Ms. Town? Seeing none, thank you very much. Mr. Jett, are you available to unmute yet? Okay, I guess not. All right, up next is Carson Tucker. Mr. Tucker, I know you asked for 30 minutes, but I can give you 8 minutes.
Yeah.
And then I have to recess this hearing and we'll have to come back another day.
That's fine. Can everybody hear me okay?
Yes.
Okay. Hi, good morning or good afternoon. I'm actually in the United Kingdom. That's where I live, in Cambridge. But I did submit a written statement and I would love for you to be able to read that. I think it's extremely important to clarify some of the misconceptions about federal law. For example, I'll go over one in particular that has been a thorn in the side. I've given you some background information about myself as well. I am a veteran. I'm not disabled. I was 24 years in the military and 27. And I'm an attorney as well, as was said before. And I was a JAG officer for 12 years. And as a JAG in the Army, the last stint of my military career, I was enlisted before that in the Navy. I sent a tremendous amount of veterans downrange, which meant I took care of their legal affairs, advised them and their families what would happen to them if they did not come back or if they did come back wounded and injured. And I can tell you that I sent thousands of veterans, deployed thousands of veterans, and they did not all come back. And the ones that did come back did not come back the same as when they left. And this has had an enormous impact upon me and the work that I have done in the last essentially 6 or 7 years for disabled veterans. It's something that I have taken very seriously. And I want to establish a misconception. Rose versus Rose is a 1987 opinion from the United States Supreme Court, which did state that the states were free to consider veterans' disability pay, even if the veteran is 100% disabled, for purposes of establishing a child support obligation. The year after Rose versus Rose, in 1988, Congress established legislation called the Veterans Judicial Review Act. They amended provisions that were referred to in Rose as allowing the United States Supreme Court to hold that way. Congress fundamentally changed the paradigm for the consideration by the states of veterans' disability pay for child support and spousal support purposes. And the reason that that's so important to understand, it was in 1988. I have seen, as the previous speaker said, firsthand, the states have spent the better part of 30 years I don't want to say ignoring, but misunderstanding and misapplying these federal statutes that restrict and limit the states from considering a very specific amount of disability compensation that's paid to veterans in child support obligations. And what it does is it allows the states to count 100% of the veteran's income, whether or not it's 100% disability or if there are other sources. It allows them to take 100% of that disability compensation and put it over in the ledger of available income. Earlier, someone asked whether there were specific legal provisions and laws. I will give you those. They are in the statement. 38 USC section 511 removed concurrent jurisdiction from the state courts to consider even the question of whether or not these benefits can be considered. Section 511 of Title 38 of the United States Code actually states that the Secretary of Veterans Affairs has the exclusive, final, and conclusive jurisdiction with respect to all questions of law, in fact, concerning a claim for benefits by both the veterans and their dependents. The reason that this bill is correct is because it allows, or I'm sorry, it defers to that exclusive jurisdiction of the Veterans Administration. The Veterans Administration and the Secretary can, and in some cases do, apportion a part of the veteran's disability compensation and allow that to be paid to the dependents in support obligations. But it has to be the VA that does that because they have the appropriations from Congress by virtue of the military powers clauses in the Constitution, which is the source of this legislation. And as some of you may know, when Congress passes legislation pursuant to its enumerated powers, the Supremacy Clause provides that that legislation preempts all state law that stands in its way. Another misconception of Rose is that the statement that states have presumptions of authority and jurisdiction over matters concerning domestic and family law. That was a statement that was stated in Rose, but in fact, every Supreme Court case before and after Rose has rejected that proposition. And in fact, Hillman versus Moretta, which is a 2015 case from the US Supreme Court, and Howell versus Howell, which is a 2017 case from the United States Supreme Court, which is the case that I was the amicus brief writer on. I'm admitted to the US Supreme Court for the Veterans of Foreign Wars. That was a unanimous opinion, agreeing with every one of the propositions we posited concerning the protection that federal law provides for these particular benefits, okay? And the statement in Rose that's been rejected is, while state family and family property law must do major damage to clear and substantial federal interests before the Supremacy Clause will demand that state law be overridden, the relative importance to the state of its own law is not material when there is a conflict with a valid federal law, because the framers of our Constitution provided that federal law must prevail. And specifically, this is a quote from the United States Supreme Court, a state divorce decree, like other laws governing the economic aspects of domestic relations, must give way to clearly conflicting federal enactments. That principle is but the necessary consequence of the Supremacy Clause of the national Constitution. That case is Ridgway versus Ridgway. It's been repeated in Hillman versus Moretta, a 2015 case from the court, and again in Howell versus Howell, the 2017 case. Now, I want to assure the committee that there is provision in the law, in federal law, for the payment to dependents of support obligations. This bill, HB 317, refers to that provision. It's 42 USC 659 H1B3 and 42 US 659 H1A25. Those two provisions explain clearly when the states can and when they cannot count as quote unquote remuneration for employment, which is income, these benefits. The issue here, and I think it's a cultural issue as well as an economic issue, and it's an issue that relates to the fact that we have been at war on one sense or another for over 30 years, multiple theaters of operation, significant injuries. We have over 5 million disabled veterans in the United States. 70% of that number is greater than 70% disabled. And they're not retirees. These are people that go into the military, spend 4, 5, 6, 7 years. They get injured and wounded too much to continue in that career, so they become disabled and medically discharged. We're not talking, yeah.
I'm sorry to interrupt, but we have to stop now. I'm going to have to recess this public hearing to a future date and time. It will be noticed in the calendar. Those who have not had the opportunity to speak yet will have to sign up again. And Mr. Tucker, I will put you down as the first speaker. Just be sure to sign up again.
Okay, thank you very much.
And it's noticed in the calendar. All right. So I am recessing the public hearing on House Bill 317, and we will be in recess until 1:15. you hear me, Christina? Good?
Yes, thank you.
Thanks so much.
You'd be glad to know I do have a laptop and I just have to get it configured enough so that I can use it.
Oh, because you're getting your internet.
Oh, no, I got it.
Oh,
Since
you did?
Friday of last week, I got it.
That's right.
And, you know,
Cool.
everything changed.
All right.
On the other hand, I'm figuring to come in for committee meetings anyway.
Yeah. Got 2 minutes, okay?
What kind of a cell phone do you have?
I have a track phone.
Okay.
Oh, yeah. Well, there's no cell phone reception where I live either, so it's just no point in having a fancy phone. But there are lots of good things about it, like mud season.
I love them. Country is happy. I love country. All right, so I don't have Representative Chesterman on this. Oh, but look, there he is. One more minute. I'm just going to go on and clarify what I did earlier. Good afternoon, everyone. Thanks for coming back. I appreciate it. I just wanted to clarify before we start the next hearing. I know I sounded a little confused last time because I said recess twice, but we are going to, we are recessing 3/17 to another date. Okay, and when I said recess, I meant we were recessing for lunch, but 3/17 will be rescheduled to another date. Okay, as will, unfortunately, House Bill 68, I haven't scheduled a half an hour for it, and it's gonna take a lot longer than that. So I'm gonna have to reschedule that one at 1:45. We'll get through as many as we can, and then we'll have to, that one will have to be rescheduled also. Okay? So is everyone ready? Did everyone have a good lunch? Yeah. Good, good. Okay. Madam Clerk, are you ready? Yes, okay. All right, so I'm gonna open the public hearing on House Bill 68, and I will call up the bill sponsor, Representative Dave Tusterman.
Madam Chair,
Yes?
I thought we have to do a roll call to make sure that we're all present.
No, not after lunch. Do we have to do that, Christina?
No, I can see that there is a quorum present, so we don't need to do that.
Oh, okay. Well, thank you anyways, though, Rep. Wazir. Way to have my back. I appreciate that. Okay, so Representative Tusterman.
Oh, this is Dave Testerman. I represent 2 wards of Franklin and the town of Hill. This is my 3rd term. I'm bringing a bill to you today, HB 68. It's a relatively straightforward. It's about 2 sentences. It just changes one, it adds in a definition to one of the cases for child abuse. I don't care how parents want to dress their kids, how they want to address their kids, things like that. not my business to get into. As the bill says, I'm just talking about drugs and operations or surgery. It's a little bit like, cutting off a finger that a little boy points at you because it represents a gun. That's not something you should do, of course. A couple of years ago, we banned female genital mutilation. It's a law now, and of course, we don't want to be doing that in a case like this. Using puberty blockers. These are hormones that are used to slow down the puberty cycle, or in fact, sometimes, stop it altogether. It's not really a healthy. In many cases, it has long-term effects. It ends up with suicidal tendencies, blood clots, brittle bones, things like that. What would have been a year and a half ago, I talked to a person who had gone the complete route. He was very unsatisfied with his life. He decided to change it and had an operation and took all the hormones and so on. The interesting thing he said was, I still have the same problems I did before, the same concerns and so on. So it's somewhat a pointless issue. I know a lot of people talk about it, but it's really, it's somewhat nonsensical. All I'm trying to do is protect young kids. By the time most children are 20 to 25, they'll have decided whatever their sexual preferences are probably the same ones they were born with. It's high percentage of that. And with that, I'm open to questions.
Thank you. Are there any questions for Representative Testerman? I have one. Representative Testerman, do you have a medical degree of any kind?
I do not. I'm an engineer.
Thank you. Okay, I guess that's, Representative Belanger.
I have 4 children and 12 grandchildren, so I know a little bit about them.
Thank you, Madam Chair. Representative Testerman, who would you propose follow through with these child abuse complaints?
The same ones that do for all other kinds of child abuse.
So you're referring to sorry. So you're referring to DCYF?
Yes.
Another one?
Follow up, please.
Go right ahead.
Are you aware of the caseloads that these caseworkers are currently dealing with now?
I am, this is a situation that I think is important, and it should be taken care of by DCYF. That's no excuse for DCYF not to do their job.
And one more follow-up.
And one more follow-up.
And why, sir, do you feel like this should be child abuse?
Well, it clearly makes a physical change, either through drugs or through surgery, that just makes no sense to do. It's like I said earlier, would you cut off the index finger because a little boy points it and uses it as a gun? Just doesn't make any sense.
Thank you.
Representative Cross.
Hi, Representative Testerman. Are you aware that when these children go see doctors for, let's say, surgery, there are multiple check boxes that they have to hit before the doctor will do any type of surgery?
Yes, I am. I've seen some of the checklists. In this case, because I'm only talking about children, you would have to delay it until age 18. They're still a child at that point.
Representative Smith.
Hello, Representative Testament. My question, I have two quick questions. One is, there's a very different, there's a big difference between a child that's 6 and wants a sex change and a child that's 16 or 17 that has been through a lot more of the counseling, the medications, and the doctor's appointments with their parents. You're proposing that the parents get criminally charged with child abuse for that when they've been working with doctors and probably therapists along the way?
Well, up until the age of 18, if that's what the abuse law calls for, then that's what we would have to do.
So,
Okay.
Westerman, my question then would be, what would happen to the doctor then? Would that doctor be charged with child abuse?
I'm not sure how that goes, but it supposedly, he was one of the reporting people. He would have to report it. If he didn't report it, he would be guilty of child abuse.
Would he also be guilty of child abuse if that child ended up committing suicide because it didn't get the treatment it needed?
I think that is a case that these children are, they do have a higher suicide rate. Having that kind of operation and that kind of drugs won't reduce it.
Do you have statistics to back up those facts?
I don't have them with me.
Could you get those to the committee, please?
I could, yes.
Thank you. Representative Cross.
Oh, Madam Chairwoman, I had another follow-up question.
I apologize. I'm sorry. Representative Cross, just 1 minute, okay? I'm sorry. Go ahead. I'm sorry, Representative Smith.
Representative Testerman, if you are saying that parents are criminally responsible for having their child go through a medical treatment like that, could it not be, like, where does this end? So could you then charge a parent if their teenage child has an abortion? Many would possibly think that that is child abuse.
I'm not talking about that. I'm just talking about this one specific situation.
I know, but you're opening the door, is what I'm saying.
I don't believe I am opening the door. I mean, you have definitions of abuse. Does that open the door for me? I mean, I just think it's a ludicrous comparison.
Okay, thank you.
Representative Cross.
Representative Testerman, do you have any proof of any plastic surgeons performing surgeries, top surgery, any kind of surgery, changing their bodies in any way before the age of 18 in New Hampshire?
I do not. I know of some cases nationally, but I don't know in New Hampshire.
Thank you.
Are there any further questions for Representative Testerman? Seeing none, thank you.
I'll be leaving.
Have a nice day. Next up is Anya Tang to speak in opposition.
Hi.
Hi, go ahead, we can hear you.
Awesome. Members of the committee, my name is Anya Tang. I am a 17-year-old trans person who goes to school in New Hampshire. I oppose House Bill 68 because I believe that denying me the healthcare I need to feel safe and affirmed is abuse in and of itself. Under House Bill 68's proposed changes, I would not be able to get the surgery nor the hormone treatment I need for my mental and physical health. When I was young, whenever I looked in the mirror, I never ever saw a body or a face that I could call mine or feel comfortable with. I have been trans for as long as I've been able to think and feel and move, and I can confirm it's not a phase. And if it is, 17 years is an awfully long period of time to call a phase. Before I even knew what word to call myself or what to call myself or what I was, I learned about transness through someone called Leila Alcorn. Her name was Leila Alcorn. She committed suicide on December 28th, 2014, because she never received the gender-affirming care or support she needed. For months, I followed eulogies, articles, and comments calling her by the wrong name and the wrong pronoun. The first trans youth I ever knew, I knew through death. Why is this? Joshua Safer, the executive director of the Center for Transgender Medicine and Surgery at New York's Mount Sinai Hospital, finds that suicide attempt rates are as high as 40% among trans people who don't receive medical treatment when they need it. My identity as a trans youth is and should be a basic human right. I should have the freedom to be myself. The rest of the nation is working to respect that already. The Human Rights Campaign finds that in 2010, just 9% of companies offered healthcare benefits that cover gender-affirming surgeries and treatments. Now, as of 2019, that number has gone up to 83%. Additionally, Medicare, the government program for the elderly and disabled, has already begun offering gender-affirming surgeries since 2014. What we need isn't a step backwards with House Bill 68. We need to keep on moving forward, and that means opposing bills like these. Gender-affirming care is healthcare, and House Bill 68 would make it illegal for me, as a minor, to receive the healthcare that affirms my identity. House Bill 68 would make it illegal for my peers in the trans community to feel affirmed and to finally feel comfortable and safe in their own bodies. Why do you think 40% of trans people that aren't able to receive medical treatment attempt suicide? When you deny us access to a basic human right, it tells me and the other trans youth in our community that there is never room for us at the table or in your policy deliberations. When you deny trans youth healthcare and push a bill that would call gender-affirming care abuse, you are telling our families that you are able to intervene in our personal lives and tell trans youth like me what our bodies are feeling. This bill is a violation of my basic freedoms and my basic right to access healthcare that is important for my well-being as a trans youth. Trans healthcare is not female genital mutilation. Puberty blockers are not, quote, cutting off a little boy's finger. Denying us the option is never a pointless or nonsensical issue. Representative Testerman calls these changes nonsensical. Representative Testerman is a cis person. He has never felt gender dysphoria, the distress caused by a trans person's gender differing from their sex assigned by birth that comes with not getting the healthcare you need as a trans youth. He lacks a medical degree of any kind. He has never known how awful and how painful it feels when you don't feel at home in your own body. Representative Testerman does not know what I feel. He will never, ever access the experiences I see and I feel as a trans youth. I am telling you as a trans youth to oppose House Bill 68 because Representative Testerman's legislation is not informed by the experiences nor the interest of trans youth and their families in mind. Being able to transition as a trans youth at home with the support of family that can act as caretakers is the best way to keep trans youth healthy in a safe environment. It is not abuse, but rather affirmation. A Yale University study found in 2020 that for trans folks that received gender-affirming surgery, suicide attempts dropped to 0 up to 3 years after their surgery. Furthermore, a 2018 study published in JAMA Pediatrics corroborates that out of 68 trans youth that received gender-affirming surgery, virtually none of them experienced any regret up to 5 years after their surgery. In fact, their dysphoria was significantly reduced as a result of the surgery. This type of healthcare works. This type of healthcare is what me and many other trans youth need to continue having access to. Maintaining the ability for trans youth to receive gender-affirming surgery and treatment gives us the ability to transition with our families before we leave for college or before we leave for the workplace, both of which are unfamiliar environments that may separate trans kids from our support systems that would otherwise help us transition. Doctors, activists, academics, families, and trans youth have all provided countless reasons and statistics and studies to support maintaining access to gender-affirming surgery and treatment for trans youth. None of it is ever abuse. You should join us in opposing House Bill 68. Opposing this bill is an opportunity to signal your support for the trans community in New Hampshire and across the nation, because opposing this bill is a recognition that access to healthcare is a basic human right, and that a recognition that families have the freedom to work with their trans youth in deciding if gender-affirming care will help them. It is a recognition that access to healthcare for trans youth is not abuse, but affirmation. It is recognition that doctors, families, and most importantly, trans youth know what is best for them, not someone without a medical degree. Opposing this bill signals to families that they have the right to choose gender-affirming surgery and treatment for their trans youth, and is a step forward that needs to happen along with the rest of the nation. Trans kids are just like any other kids. We hang out with their friends, we help out in our community, and sometimes we testify before state committees when there's an issue we especially believe in. Treat us just like any other kid and vote to maintain our access to healthcare that we need access to as trans youth. Thank you.
Thank you very much. Are there any questions for Ms. Tang? Seeing none, thank you very much for your testimony. Did you send in written testimony, by the way?
I did. I emailed it up to an hour before the hearing.
Great, thank you. Okay, up next is Lindsay Collins, who has asked for 5 minutes.
Hello, can you hear me? Thank you. I won't need 5 minutes, but I will go ahead and get started. My name is Lindsay Collins, and I'm a member of the public, a concerned parent, and a youth outreach worker with trans youth. I oppose this bill because I believe it is harmful to trans youth and their guardians in the state of New Hampshire. It is not the state's place to make a decision on whether or not someone should receive gender-affirming medical care, much less define it as child abuse. This could be harmful for trans youth. Trans youth need our support and need to be equitably included. They are some of the most vulnerable in our community, and this could in fact lead to worsening of mental health issues. I believe this bill is a danger to trans youth and their families and is very discriminatory as well. Thank you for your time and consideration.
Thank you so much. Did you send in written testimony?
I did not, but I can forward it to the email.
Okay, great. Thank you so much.
Thank you.
We have to cover one thing. I need Representative Trigno. Is he still here? I just need you to state that you're here and if where you are and if you're home alone and whatnot.
Yes.
Like you do.
I joined the hearing at 11 o'clock this morning. I am home alone in my office.
Great. Thank you so much.
You're welcome. Thank you.
Okay, up next is Allison Brial, who has asked for 5 minutes. Allison, you can go ahead. Allison? You can go ahead. And if you have that screen says up there.
I think it says click to unmute.
Okay, so most system resources may affect your quality, which means basically the way people use the Wi-Fi here.
Okay. All right, give me 1 second. Allison Brial, can you hear me? It looks like you're unmuted. Can the members of the committee hear me? Yes, okay. So I don't know what's going on. So I'm checking with community researcher for help. All right, so can you go out and come back in, Allison, and I'll call you when you get back in. And I'll go to the next person. Is that correct, Christina?
Yes, I see that she's unmuted, but it looks like we're not able to hear her, so we'll see if she can get back in.
Okay. So why don't we go to Karina Torres? She's not on. No. Okay. How about Timothy Taberge?
Not here.
Not here. Okay.
There's Valerie.
Valerie Murphy?
I don't see her. Wilson, I do not see.
Kelsey? No, Kelsey. No, Kelsey. Sorry. Kelsey Wilson?
Kelsey.
Okay, Christine, we're gonna pull you up. There we go.
Hello. Hi, can you hear me?
Yes, thank you.
Hi. Dear members of the House Committee on Children and Family Law, my name is Dr. Christine Arsenault. I am a pediatrician and the vice president of the New Hampshire Pediatric Society, which is the state chapter of the American Academy of Pediatrics, which represents 242 pediatricians in New Hampshire. My testimony is on behalf of that organization, as well as the New Hampshire Medical Society, which represents more than 2,200 physicians, medical students, and medical residents in New Hampshire. We strongly urge you to vote no on House Bill 68, which would cause incredible harm to the health and well-being of transgender youth in New Hampshire. It can be hard to understand what it is like to have a transgender child, especially if you've never met someone who is transgender. Parents of transgender children, like most parents, simply want to do what is best for their child. In addition to harming transgender youth, this bill would directly interfere in the physician-patient-family relationship and harm pediatricians and other medical professionals who provide comprehensive, evidence-based care for transgender youth. Medical professionals, not politicians, should decide what medical care is in the best interest of a patient in conjunction with the patient and their family. 1.8% of youth identify as transgender, and a further 1.6% are questioning or gender diverse. This is not an easy path for many children and teenagers. Around half of these children consider suicide, and a third attempt it. We know that if youth are provided with appropriate gender-affirming care, the risk of suicide falls dramatically, and transgender people have every opportunity to live their lives in good health. Medical care for transgender youth is evidence-based and has proven effectiveness. Guidelines for appropriate treatment are carefully developed and endorsed by the American Academy of Pediatrics, the American College of Obstetrics and Gynecology, the Pediatric Endocrine Society, the American College of Physicians, the World Professional Association for Transgender Health, and the American Psychological Association. Medicaid and major insurance companies in New Hampshire cover gender-affirming care. In fact, until very recently, the HHS Office of Civil Rights required coverage from all insurers, and these rules will likely be reinstated. These medical guidelines provide for the evaluation of children with gender diversity or gender dysphoria. Some of these patients identify as transgender. Before puberty, there is no medical or surgical treatment that is used at all. Guidelines emphasize supporting children as they express themselves. Treatment for these children can include letting them select the clothing they prefer, getting a new haircut, or using a different name. This is called socially transitioning, and this measure alone has been shown to decrease suicide rates. Children with gender dysphoria undergo detailed, repeated psychological and medical evaluation with the participation and consent of their parents. Only after the onset of puberty is medical treatment ever used, and only in some patients. Treatment with medications to temporarily suppress puberty is reversible and allows the patient time with their ongoing medical supervision of their doctor to explore their gender identity before committing to a treatment path. These puberty suppressing medications are commonly used for other conditions, such as early puberty and prostate conditions in men, and their safety is well established. Later, teenagers can elect to receive hormonal therapy if it is indicated, generally after the age of 16 and after living in their authentic gender for some time. Fewer than 1/4 of transgender patients ever have surgical procedures, and these are generally recommended after age 18. This bill would make providing evidence-based medical care according to nationally recognized medical standards of practice a crime. Providing patient care that helps rather than harms is our duty, according to our oaths as doctors. This bill sets a dangerous precedent and puts politics rather than medical expertise ahead of our patients' health. This bill is an extreme attack on transgender youth in New Hampshire and will criminalize access to evidence-based medical care for this vulnerable population. By all standards, this bill is also an egregious attack on pediatricians and other medical professionals' ability to provide evidence-based medical care. I urge you to vote no on House Bill 68. Thank you very much for your time.
Thank you very much. Are there any questions for Ms. Arsenault? Seeing none, thank you very much. Now I'd like to go back to Allison Brial. I see her in the waiting room, so we will have her. Allison, you had asked for 5 minutes, so I'm going to ask you to keep it to the 5 minutes, okay? Did you get her? There she is. Almost there. Okay.
Can you hear me now?
You are, yes.
Oh, wonderful.
Keep it to the 5 minutes that you requested though, because we're going.
And I won't even need that much because I feel like all these speakers have already said much of what I wanted to say, especially the first speaker. I applaud that individual so much, such passion and knowing themselves so well. I am speaking as a parent of a transgendered son, as well as a nurse and a future nurse practitioner. What I have seen is the psychological damage that can happen from somebody who is not allowed to be themselves. And a bill like this would destroy my son even more. He has self-mutilated. He has contemplated suicide. And according to different research out there, over 50% of transgender youth either contemplate or attempt suicide when they don't have appropriate treatment. Right now, my son is on a hormone blocker. This is reversible. It does not do any damage to him. All it's doing is stopping him from getting a period, which is very traumatic. Soon, hopefully, he'll be starting testosterone, which has made him so happy. I can't even explain that much. And I really wish that Representative Testerman could be here to hear these things. I'm happy that he has kids and that he's never had to experience the hardship of a child wanting to kill themselves. And maybe if he had, he'd have a slight bit of empathy for this. But I'm pleading with this House to not pass this, to vote no, and to show all the youth in our state and in our country that we want the best for them, that we love them, and that we support them. Thank you.
Thank you. Are there any questions for Ms. Brial? Okay, seeing none. Thank you very much. Have a great day. So unfortunately, I am going to have to recess this hearing because there were 69 people who signed up in advance for this, to testify on this bill, and we just don't have the time for it today. So I'm going to have to recess this to a later date and time to be noticed. Those that have not had the opportunity to testify will need to go back on the general court's website and sign up again for when we do it. I'm sorry, I never imagined there'd be over 70 people because there's still people with their hands up. So I'm going to have to recess this hearing and we will take it up, not next week, but the week after. I'll get a date and time and it'll be noticed. Okay, thank you very much. Sorry. Okay, and then next up is, I'm gonna open the public hearing on House Bill 60. And I'm going to call on, Representative Levesque. This is your bill, correct?
Hello, can you hear me?
Yeah, Dave. Yeah, you're good.
My name is Representative. Okay, my name is Representative Cassandra Levesque. Good afternoon, Madam and honorable members of the committee. Thank you for allowing me to speak on behalf of HB 60. With this bill, we hope to raise the age for an end child marriage in New Hampshire. Why am I determined to end child marriage? The answer is simple. Marriage before age 18 can have devastating lifelong impacts on people's lives, undermining their health and education, economic opportunities, and increasing their risk of experiencing violence. For the past 5 years, I've worked to raise awareness and attempted to end child marriage. I have talked with survivors, their history, held their hands, and cried with them. I have made connections and partnered with organizations who work on their behalf, and I am beyond pleased that so many are here with us today. Today, we also have survivors here with us. Some are ready to share their histories, some are not and are just watching the proceedings. We also have representatives from some of the preeminent organizations on the forefront of this campaign, leading with research, data, and experience in the field. They are here to help dispel myths and provide sustained information that should answer any remaining doubts that the marriage age floor needs to be raised. The hardest part of today is going to be setting aside what you think and listen to the facts and data being presented. It's easy to get comfortable with what we think is the right way of things, but times change. Data is gathered and we move forward. Sometimes we have to leave something damaging in the past and move on to a better future, one that empowers people instead of harming them. In the past, I have shared the story of my grandmothers, Agnes and Fanny, but I want to continue Fanny's story today. We know that child marriage has generational effects. As a reminder, Fanny was 16 when she married a 49-year-old man. Fanny's husband was an alcoholic and was verbally and emotionally abusive. Fanny's daughter, Bertha, when she married a man who would become an alcoholic. He was brutal with her, and their marriage ended in divorce. Bertha had 4 sons. Her eldest son would become an alcoholic, whose own marriage ended in divorce. His children fight addiction to this day. Her second son abused drugs, alcohol, and was bipolar. Her third son abused drugs, alcohol, and his marriage ended in divorce. His children struggle with addiction to drugs and alcohol, mental illness, and have a history of having abusive, failed, or toxic relationships. Recently, my family reconnected with one of my cousins. She was married as a teenager, and her husband was physically and mentally abusive. She got into drugs, her marriage ended in divorce, and she is working to move on to a healthier life for her and her daughters. Child brides are neither physically nor emotionally to become wives and mothers. They face more risk of experiencing dangerous complications in pregnancy and childbirth, contracting HIV and AIDS, and suffering domestic violence. With little access to education and economic opportunities, they and their families are likely to live in poverty. Generation after generation of my family has been affected by child marriage. Going to college is still a very rare occurrence in our family. Most of the side work paying jobs and live right along the federal poverty line. Child marriage is insidious and it affects generational. Some people feel that 16 and 17-year-old children know what love is and fully understand what they are potentially getting themselves into. However, I have heard from many victims who disagree with this, and they have shared their stories with me. Their voices will forever echo in my heart and in my mind. A few examples of what I have been told by victims of child marriage are, my husband put a dog collar around my neck, trusts me up on the floor in front of my parents just to prove to them that he can control me. Another, my husband was a monster. Another, I was alone. My husband was deployed to Germany and I had a high-risk pregnancy. My parents flew my sister to California to come and drive me across country so that my family could help me with the birth of my son. My husband did not see his son until he was 19 months old. They never bonded. Another, I was 16 and I wanted to escape an abusive living situation and myself in. I married a sailor, and when he came back from his deployment in Hawaii, he used to verbally assault me and tell me of all the other women he had been with. He hit my self-esteem and tried to control me. I left the marriage with my infant daughter. As you will no doubt hear today, many children find themselves in a marriage situation that is a much larger problem than they thought possible. There is a significant difference between a 16 or a 17-year-old, even one who is exceptionally mature, and an 18-year-old. The 18-year-old has reached the age of majority in New Hampshire. This is crucial when we are talking about marriage, a serious legal act. To enter into any contract, you have to have the legal capacity to give consent. To give legal, valid consent, a person must possess the cognitive abilities to understand the basic nature of the marital obligation and to voluntarily agree to marry. To sustain modern marriage, a person must possess core aspects of psychosocial maturity and other abilities. While children and adolescents may have attained the former abilities by mid-adolescence, age 15 or 16, they will not attain the latter psychosocial maturity until late adolescence or emerging adulthood, the early 20s. Children do not have the right to marry. The marriage age has already been set at 18. With HB 60, we are empowering by ensuring that they wait until they can decide on their own as legal adults whether and whom to marry. Child marriage has no redeeming quality, period. It offers no benefit to children that cannot and should not be found elsewhere, and it brings countless serious harms and risks. We do not allow exceptions to the smoking or driving age. We set those ages based on when people can engage safely in those activities. We should not do the same with marriage. Age-up marriage has for decades been the strongest and most unequivocal predictor of marital failure. The likelihood of divorce nears 80% for those who marry in the mid-adolescence, then drops steadily. Delaying marriage until the mid-20s reduces one's likelihood of divorce to 30%. Women who married at age 21 or younger experience worse mental and physical health, attain less education, and earn lower wages than those who marry later. I've also been approached by people who ask, but what if a girl is pregnant? In response, we have to keep in mind that New Hampshire ranks number 49 out of 50 states for having the lowest teen pregnancy numbers in the country. Contrary to what U.S. policymakers used to believe, pregnant teenagers who stay single actually have better long-term outcomes than those who marry. Teenage mothers in the U.S. who marry then divorce are more likely to suffer economic deprivation and instability than teenage mothers who stay single. We as lawmakers have an obligation to our citizens to lead them on the path of success. New Hampshire has made sure that the tools empowered these girls are available. They can access insurance through New Hampshire Medicaid. Services are available. Start Smart programs. Community action partnerships can help with their services of childcare, home visits, and supportive services. Girls can get the parental care they need through a variety of sources located throughout the state. They can get rides to the care provider. In 2021, to think that a pregnant teen is on their own is a ridiculous, outdated notion. Marriage should not be encouraged just because it's viewed as a solution to a problem. Pregnancy exceptions to the marriage age have been used to cover up rape and to force girls to marry their rapists. Marriage license data obtained from across the U.S. shows a number of child rapists recently were handed marriage licenses instead of prison sentences. If New Hampshire creates a pregnancy exception with other states move in the opposite direction, New Hampshire can easily become a destination wedding site where parents take their daughters who have been raped to force them into marriage. That is not what we want New Hampshire to be known as. The New Hampshire U.S. the U.S. State Department has called marriage before the age of 18 a human rights abuse. Humans have the right to education, yet we know girls who marry before 19 are 50% more likely than unmarried girls to drop out of school and 4 times less likely to complete college. We also have the right to live our lives free from violence. We have the right to employment, freedom of movement, and the right to consensual marriage. Child marriage denies many of the victims those rights. According to the United Nations Conventions of the Child Rights, a child is defined as a human being below the age of 18. In all actions concerning children, whether undertaken by public or social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. According to Article 19, states parties shall take all appropriate legislative, administration, social, and educational measures to protect from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse, while in the care of parents, legal guardians, or any person who has the care of the child. We cannot say we're acting in the best interest of the child when studies show the devastating, long-lasting effects that marriage before 18 has on life. It shatters their health, education, and economic opportunities and increases their risk of experiencing violence. How much longer will we wait before it's time to stop this practice? How many more victims will there be? How more lives will be destroyed? The time to end child marriage is not in the future. The time is now. Thank you for allowing me to introduce HB 60 today, and I will answer as questions as I can.
Are there any questions for Representative Levesque? All right, seeing none, thank you very much. So up next, I'm going to call Representative Mary Beth Walls.
All right, I'm here. Can you hear me?
Yes.
Great, thank you so much. For the record, my name is Mary Beth Walls. I am the representative for Merrimack County District number 23, which is the towns of Bow and Dunbarton. I'm in my 7th term. And for purpose of this testimony, I want to point out that I'm a lawyer who's actually currently certified in 4 jurisdictions to practice, because the main point of my testimony today, and there are others that are going to address other issues, but mine is to address some of the legal consequences facing New Hampshire in this bill. So I'd like to start with pointing out that under our current law, our current marriage laws in New Hampshire are unconstitutional. And they are unconstitutional because we require people going into a same-sex marriage to be 18 years old to be married. For a heterosexual marriage, the requirement is only 16. That is clearly an unconstitutional discrepancy here in New Hampshire. And passing this law and raising everybody to the age of 18 would fix that unconstitutional discrepancy. So we are, as we sit here today, in serious danger of being sued over this. I'm frankly surprised it hasn't happened yet. But I wanted to start out with what perhaps is the most significant legal problem with our current laws, and that is the unconstitutionality. Many of you have heard me speak before. We have addressed this a number of times in committee over the last few years. And one of the things that we did in committee was we raised the burden of proof in marriage. So for a minor child to get married today, they need to go and get a judge's approval in a New Hampshire court. And that standard before was the lowest possible standard. And we raised that standard to the mid-level standard of clear and convincing evidence. So now when a child goes to court, the judge has to find by a standard of clear and convincing evidence, which is about a 75 or 80% standard, that it is in the best interest of the child to approve that marriage. So our hope was that this would drop the number of child marriages in New Hampshire. We passed the law in 2018, effective the beginning of 2019. It's now been in effect 2 years. While I don't have the data on child marriages in 2020, I do have them in 2019, and the marriage rate is unchanged. So it unfortunately did not drop the rate of child marriage at all in this state. I will tell you there's been some sort of natural drop. I've got the data from 2000 on. And from 2000 to about 2011, we had double-digit number of kids, anywhere from 12 to 25, who were getting married in the state. Since then, it has dropped, and from 2012 on, it's been in the single digits. And last year, for the last year, I have data, which is 2019. There were 5 child marriages. The vast majority of them, 85% of them, involve a woman or a young girl actually being married to a man. And while now many of them are similar ages, there's still a third of them that are marrying people who are significantly older than they are. So the courts are still rubber stamping this, and that causes some concern. I'd also like to talk about a little bit legally about how we treat children under the law. There is extensive evidence out there that many of you are aware of about the physical or lack of physical and emotional maturity of children. And we have recognized that in the law. You have to be 18 to vote. You have to be 18 to sign a contract, to sign a lease, to open a bank account, to buy a house, to buy a car. At 16 and 17, you cannot smoke. You cannot drop out of school. At 16, you cannot enlist in the military. You are still subject at 16 and 17 to the delinquency laws in our state. And when a child goes to toast themselves at a wedding, when it's a child marriage, they can't do that because they're not old enough to drink. Across the board, we recognize 16 and 17-year-olds as children. And by failing to recognize them here, we are making a major mistake. We know that children who go into marriage are 80% of those marriages are likely to end in divorce. That means of the 5 children that we know that were married in 2019, 4 of them are probably already divorced because most of those divorces happen within the first year. We know that the education dropout rate is much higher. We know that this leads to a lifetime of poverty for those. We know that this poverty extends into multi-generational, as it did in Cassie's family. We need to recognize that 16 and 17-year-olds are still children when it comes to marriage. We need to pass House Bill 60, and we need to fix this unconstitutionality in our law. And I'm prepared to take any questions.
Thank you, Representative Walls. I have a couple of quick questions. Can you refresh my memory when the last change in statute went into effect?
I pulled statutes this morning, and it looks like the last amendment was done in 2019, the last that I could see.
But do you know when it went into effect?
I think the first of the year. I think it was the one that changed the burden of proof. I'm not 100% sure. The way the laws are, the statutes are presented in the RSAs, it's not immediately apparent. You can see the date, the last year of change, but you can't exactly see what the change is. But I was hunting through old bills on our website today, and from what I can see, that's the most recent change.
Okay, thank you. And just the one regarding emancipation, didn't we just change the emancipation statute 2 years ago, was it?
I think that was about, I did not look at the emancipation statutes this morning, I'm sorry, but I think it was the same year. I do think that it was in 18 that we changed it and probably went into effect in 19.
Okay, thank you. I'm going to have the committee researcher send us the emancipation statute and the current marriage statute, and to also find out the exact date that that went into effect.
Well, the marriage statute, I can tell you, because I did find that, and it was January 1st, 2019. It was signed in 18 and went into effect in 19. I suspect the emancipation is the same, But if they look at the bills that were in 2018, you're going to find that's where those bills were.
Okay, thank you. Are there any further questions for Representative Walls? Representative Belanger?
The vice chair can go first. Okay.
I called on you. Okay.
Representative Walls, excuse me. Of the list that you named, when you talked about being able to smoke or sign up for the military, or of that list, how many of those are you aware of that you need parental approval to be involved in? Because correct me if I'm wrong, you can sign up for the military under the age of 18 if a parent does sign for you.
Representative Belanger, I wondered that. So I researched it this morning, and honestly, I'm not an expert on it. And there are witnesses beyond me that know more than I do. I know they're going to testify. But what I found when I was Googling it is that you can enlist at 17. It did not appear that we can still enlist at 16, but it does. They did say you can enlist at 17 when I was trying to research that.
Follow up, Madam Chair. So just of the list that you named off, can you give me can you give me any others that would need parental approval?
Well, I'm sure with opening a bank account, you could open it jointly with parents. That's not quite approval. I'm sure on buying a house, a parent, or a car, a parent could co-sign a loan. Again, that's not approval. That's really them putting themselves out there at the same time. I can't see anything else in here where you need parental approval.
Thank you.
Representative DeSimone?
Thank you, Madam Chair. Thank you for taking my question, Representative Wells. Can you tell me what constitutional article talks about same-gender marriage?
Well, nothing specifically addresses same-gender marriage. What it addresses is we're talking about the Equal Protection Clause. And so it's really the 14th Amendment. And when you look at the 14th Amendment, the Equal Protection Clause says that you've got to treat people in a similar way. Similarly situated people in a similar way.
I see. Thank you.
You're welcome.
So Representative Walls, I just have one more question because I'm going to get the statute and look it over, but I could have sworn that we amended the marriage bill so that we wouldn't run into that problem. I thought we included same-sex marriage in that bill. Am I wrong? Or
I did not find it when I was researching it and you know, Kim, this is my 7th term. I've been doing this a long time. I don't recall, but when I was looking it up, I did not find that. You could be correct on that. But honestly, my recollection was not the same as yours.
Yeah, but my recollection isn't that good, so I'll have to look at it. Okay, are there any further questions for Representative Walls? All right, seeing none. Seeing none. Thank you very much, Representative.
Thank you.
Okay, and up next, we're going to take Representative Altschuler. Oh, I'm sorry, I have a.
Thank you very much, Madam Chair. I unmuted ahead of time this time. So thank you, committee members, for your time and attention to this really important matter. Marriage is a contract. People in New Hampshire cannot enter into legal contracts before they reach the age of majority, which is 18. It's the threshold of adulthood as recognized in law. And I submit to the committee that the people in New Hampshire under the age of majority who must seek parental and judicial approval to enter into a contract, which they may not exit until they actually reach the age of majority, is a manifestation of coercive control. Coercive control creates an unequal power dynamic in a relationship. It's a form of domestic abuse and intimate partner violence. It describes a pattern of behaviors a perpetrator uses to gain control and power by eroding a person's autonomy and self-esteem. And this includes acts of intimidation, threats, and humiliation. The younger the adolescent, the more likely it is that if they are sexually active, they have experienced coercive sex. This is the core understanding that underlies our statutory rape laws. And coercion is one of the 3 warning signs of the presence of human trafficking. According to the research conducted by the Tereri Justice Center, nationally, girls and young women ages 16 to 24 experience the highest rates of intimate partner violence among all such victims, and girls aged 16 to 19 face victimization rates almost triple the national average. Yet in most states like New Hampshire, while girls ages 16 to 17 make up the vast majority of children who are being married off, they are least protected by minimum marriage age laws. The US State Department has devoted an entire page on their website to this issue, and they recognize marrying children off before the age of 18 as a human rights abuse. Additionally, the United States Citizenship and Immigration Services has devoted an entire section of their website to this phenomenon of forced marriage and marrying children under the age of majority off. In the USA, 26% of women and 15% of men who were victims of contact sexual violence, physical violence, or stalking by an intimate partner in their lifetime first experienced these or other forms of violence by that partner before the age of 18. Choosing a partner is a major decision, one that should be made freely and without fear or coercion. It is a contract that one should be able to enter into and exit out of without age-based penalties or thresholds. The United States, without age-based penalties and a threshold entrance of 18. The United Nations Population Fund released a report in 2020 entitled Against My Will that unequivocally states existing laws against child marriage should be enforced, especially when girls at risk of child marriage or who are already married seek protection and justice. And where it is not yet the case, the legal age of marriage should be raised to 18 without exceptions. In the US, 200,000 children under the age of 18 were married off between the year 2000 and 2015. PBS Frontline dug into that number and discovered that more than 80% of those children who were married off to someone substantially older than them. People are not a commodity to be traded. They are not objects to be coveted, nor are they burdens to be discarded. Raising the floor, the entrance into the contract of marriage to be 18 years old for all New Hampshire citizens will be a meaningful step in curbing the violence present with the coercive control of marrying off minors. I thank you for your time and attention. My testimony has been submitted to the Child and Family Law email.
Thank you very much. Are there any questions for Representative Altschuler? Seeing none, thank you very much.
Thank you.
Next is going to be Representative Grassi.
Can you hear me?
Yes.
Okay, thank you very much, Madam Chairperson. Much of what my testimony should be very brief because much of it has already been stated. I think one of the important things to note right off the fact is that the US State Department, and you've heard this, has called child marriage a human rights abuse. By the way, for the record, my name is Representative Chuck Grassi from Stratford 11, which is Rochester, New Hampshire. When a child is married off, they are 50% more likely to drop out of high school. They are 4 times less likely to attend college. And they are less likely to return to school after childbirth than mothers who are not married off. And that's important. Those that are not married tend to keep their family relationships, and they tend to go back to school because of the support facilities that they have amongst their family, which they do not get if they are out of the family and married off. They tend to be lifelong wage earners because of their lack of education. Being lifelong low wage earners, they earn 30%, will live their entire life in poverty And this is something that is multi-generational as well. So it isn't just the one single person, the young girl or young boy who marries at a very young age who is in poverty, but they tend to have more further generations in that situation. Married teens are 40% more likely to give birth to a second child within 24 months. And they are 3 times more likely to have at least 5 children. When we look at the rates of welfare in our country and within our state, a lot of times we look down on a family that has a number of children. They have a lot of children. Well, this is a rate because they probably were married at a very young age, did not finish school, have lived in poverty, and know nothing else but that, being a mother who is on welfare. Lastly, they have a shockingly high divorce rate of almost 80%. Just one other thing that I would want to address. I had a chance to talk to someone in the National Guard in the U.S. who had been in the Army, and he advises, he is currently in the Army, he's first sergeant in the National Guard, and he advises new recruits. And one of the questions he has a lot of times is, my girlfriend is pregnant. Is there a problem here? We aren't married. And he says, have no fear. You are covered. If you name her as a dependent, the child is a dependent, they are covered under the military benefits programs. So that's not an issue. I know people have brought it up in the past, and throughout the years that we've talked about this bill, that's one of the big things is that, oh, the young boy who's going off to war or going off to the military has got his girlfriend home and he needs to marry her before he leaves or she won't get the benefits. It's not true. Madam Chairman, I'll be happy to answer any questions.
Thank you very much. Are there any questions for Representative Grassi? Representative Belanger.
Thank you, Madam Chair, and thank you, Representative Grassi, for taking my question. My question to you, sir, is when you refer to, quote, married off, unquote, can you define what you mean by that?
In other words, in this situation, you have parents who are agreeing or signing off to basically transfer ownership of that young lady or young boy to their spouse. And in many cases, it's a young girl who is with a man that is much older. It's a way to get a girl out of their family. In some cases, it's not right. A lot of times, some of these young girls, they're in love, and particularly if the boy is going off into the military, or these marriages don't last a long time. They end up on their own. So when I say married off, I think it's important to look at it that way. They're not consenting to the parents aren't consenting to a marriage. They could wait till 18 if they wanted to do that. What they're doing is they're basically removing their daughter from their family.
Just for clarification, my husband in no way owns me, never has, never will. Neither does my first husband that I got married with at 19. Okay, just because I got married young does not mean I was owned by someone. Are there any further questions for Representative Grassi?
A follow-up, Madam Chair.
Follow up from Representative Belanger.
I'm 26 years old. I'm married too. I've been with my wife since she was 17 and I was 18. I do not own my wife, for the record. I agree with you, Madam Chair. Can you give me a statistic, Mr. Grassi, in regards to, sorry, I lost it. My apologies. It literally just went out the door.
It happens. Okay, Representative Long.
Thank you, Madam Chair. So Representative Grassi, I just need clarification on married out. I understand what you're saying. So we're talking about 16, 15-year-olds that are marrying 40-year-olds or 35-year-olds, not a 17-year-old marrying an 18-year-old or a 19-year-old marrying a 25-year-old. When you reference, that
could be a 17-year-old marrying a 25-year-old. And I think that the thing you're looking at as well is when I say ownership, that young girl at 16 years old cannot enter into a contract. She has to have her husband do those things for her. So in a sense, that is an accurate statement.
Okay, so follow up, Madam Chair.
Sure.
So the ownership in your mind is if I'm underage and and I'm into a contract that I can't get out of until I'm at age, that is what you're forming has ownership?
Yeah, it was probably a poor term to use in a sense, but
Okay.
the thing is yes, many girls who get stuck in that situation feel they have no way out. And, you know, when you're looking at that they have no way out, it makes it very, very difficult.
Are there any other, I have a question. Would you believe that when we passed the emancipation, the limited emancipation a few years ago, we did include marriage, so that I believe we included it so that they could contract an attorney to get out of the marriage and so that they could open their own bank account. Would you believe that?
I would.
Thanks. Representative Litchfield, do you have a question?
Thank you, Madam Chair. Actually, I believe that you just answered it, but if I could just repeat it and you clarify. My question was basically, is the bottom line concern on this bill not necessarily the age of marriage, but rather the opportunity to dissolve the union if necessary? Am I hearing that correctly?
No, it is the age of marriage specifically. It is not the right to dissolve the marriage. But to someone who is 16 or 17, getting into that situation, statistics have proven that they have it much harder in life, even if they can dissolve the marriage. When you're married at 16 or 17, a lot of that is beyond your ability to understand what's going on. You may be in a bad situation. You may be hopefully in a good situation. 80% of them turn out not to be good situations and they end up in divorce. So that's not it. It's not being able to get out of the situation. They shouldn't be put into the situation where they are allowed to get themselves into that kind of situation prior to turning 18. I mean, I know 18 and 19-year-old boys and girls that shouldn't be married as well, but our age of majority is 18.
Thank you. Are there any further questions for Representative Grassi? Seeing none, thank you very much.
Thank you.
Up next will be Nalia Amin, and I'm sorry if I did not do your name justice. He's not there? Okay, Don Tyree. Don Tyree, if you unmute, there you go.
Hi there. Thank you. Can you hear me?
Yes.
Thank you for allowing me the space to testify. Again, my name is Dawn Tyree, and I'm a member of the public. I'm a survivor of child marriage, and I'm here to support HB 60 in ending child marriage. It's never in the best interest for a child to marry. I was forced into marriage at 13 years old. And while I can relate that that's much younger than what we're talking about today, I can tell you that a 17-year-old is at risk and it has devastating repercussions. My marriage was more about abuse, control, and manipulation than love. I was married to my rapist after he got me pregnant. He had been sexually abusing me for 2 years. I was powerless over my body with no rights. Not one adult in my life talked to me about birth control. So 13 months later, I had my second child at 15 years old. There's no equality in a child marriage. Even a 17-year-old to a 19-year-old, there is no equality. It started off without equality. I couldn't register myself for school at 15 years old, and I couldn't register myself for school at 17 years old when I left him. I left at 16 years old, and when I went to register myself back into high school at 17 years old, I was told that I needed my parents. And when I mentioned that I was divorced and wanted to enroll myself in school, I was told that I needed my ex-husband to come and enroll me. I couldn't rent a hotel room when I wanted to leave with my 2 children. I was turned away from shelters, and social services advised me to go back to my parents. My ex-husband reported me as a runaway, and law enforcement threatened to take me back to my rapist. We lived below the poverty line for probably a decade. We lived without toilet paper or shampoo, and we often lived without electricity. How was I to go back to school, work, or even think about college? Investigations are dangerous loopholes. Saying that the court is going to mandate an investigation before allowing a marriage puts the minor at even more risk. She has been manipulated and coerced for weeks before the marriage to say yes. There is no way that a minor child is going to stand up against their parents or a caseworker and say, look, I'm being forced to do this. I'm being coerced. Children are peacemakers and they're going to keep the peace, just as I did. I believe that we have evolved as a nation and that our laws need to do the same. Teen marriage is a thing of the past. And yes, lots of our parents, grandparents, and ancestors married young. We're a different nation now. I think we can agree that we want our children to have the same opportunities as we did, or as most of us have. And that is to live to their fullest potential. Emancipation is not going to save this. As I said, my marriage was considered an automatic emancipation. And yet when I wanted out or needed a lawyer or wanted to enroll in school, I was helpless. Going back to the military that we were talking about earlier, my second husband was a career active duty in the Army and then Coast Guard and retired as a Navy officer recruiter. 2 of my sons joined the military, one in the National Guard and one in the Navy. They both signed contracts at 17 years old, and that contract was a promise, not a legal binding contract. So in fact, even though they signed it and promised that they would join at 18 years old, they could have backed out if they wanted to. I submitted a written testimony for myself and that of another child marriage survivor, and I thank you to the representatives that responded to those. The 17-year-old that I was allowed to interview wished that there were protections in place to prevent her from marrying. They didn't want to marry, but were told that it was in their best interest to marry. They believed that had they not married and had they stayed home, we're just talking about 4 or 5 months before they turned 18. They believed that they would have graduated from high school, felt empowered, and said no to the marriage. Thank you for your time.
Thank you very much. Are there any questions for Ms. Tyree? Seeing none, thank you very much. Next up is Casey Reagan. Well, no, my notes right here. She must have just signed it. Yeah, but she's not in the system. Oh, there she is.
Hi, can you hear me?
There you are. Yes. Hi.
Hi. So my name is Casey Reagan. I'm 17 years old and I live in North Haverhill, New Hampshire, where I attend Woodsville High School. I'm also a member of the Legislative Youth Advisory Council, and though I'm not representing them today, at the moment we are planning on releasing a statement as it pertains to this bill. I'm here to testify in support of HB 60, an act relative to raising the minimum age of marriage. I've been following this issue and Representative Levesque's work on it for quite some time, and so I'm super excited to be here today to hear the discussion and to add my 2 cents. I'm going to be graduating high school in a couple of months and heading off to college, and I'm so blessed to be in a situation where I can do that, where I've been financially and emotionally supported, and now I can take the next step in my life. Most victims of child marriage aren't so lucky. As we've already discussed, women who marry as minors are 50% more likely to drop out of high school, and those who do go to college are 4 times less likely to finish. This leaves them with a lack of opportunities for growth in their careers, making them financially dependent on their husbands, especially when there are children involved. This makes it harder for them to escape when they're faced with abuse at the hands of their spouse. And unfortunately, abuse rates are high in child marriages. Women who married under the age of 18 are 3 times more likely to be abused than women who aren't. This fact should be even more concerning considering the uptick in reports of domestic violence during the pandemic. A common argument for child marriage is teen pregnancy. Supporters want teens to be able to get married as if marriage somehow is a solution. And that's an argument within itself, but regardless, the statistics show that marriage as a result of teen pregnancy does more harm than good. Teen mothers who marry are even less likely to go to college than those who don't. And teen mothers who marry before or within 2 years of the birth of their first child are more likely to have a second child within that 2-year interval. If we really wanted to do something about teen pregnancy, maybe it's time we take another look at our state's sex ed guidelines, which haven't been updated, last I checked, since 2003. And sex ed isn't required in the state outside of learning about STIs and HIV. If we wanted to take another look into the issue of teen pregnancy, I think that's a better way to start. And as for supporting teen mothers, maybe we should invest more into programs that actually support their needs, like lowering the cost of education and childcare and paid family leave. As I said, I'm 17 years old, and I wanted to testify today because in the state of New Hampshire, I'm legally allowed to marry with my parents' permission. I flatter myself to say that I'm a pretty responsible kid. I don't drink, I do my chores, study hard, and keep my nose clean. But I'm just a kid. 3 weeks ago, I almost burned down my house making waffles. I don't even know how to schedule my own doctor's appointments, let alone how to be a wife. No one my age does. To say that 16 and 17-year-olds are mature enough to enter into the commitment that is marriage is ludicrous at best and dangerous at worst. Don't you remember what it was like to be 17? Don't you remember how young you were then and how little you knew and how much you've learned since? One of the reasons I'm so passionate about this issue is because when I hear these statistics, I don't just hear numbers. I see my friends. I see how excited we are to be starting our lives, to be planning our next few years at college. I think of the girls I know who are getting their first car, their first kiss, who are pulling all-nighters to finish their chem homework and scraping by on 3 hours of sleep and an ungodly amount of iced coffee. I think of them, and it makes me want to cry to think of them being put into a situation where they get married within the next year. We are so young. We don't know anything. We don't know what we want to do with our lives. Most of us haven't even had our first boyfriends yet. We're not ready to be wives. And if there are teens out there who think that they're ready to settle down with the love of their life before the age of 18, at most, this bill would only be an inconvenience. This bill is about giving girls every chance at life. We deserve to grow up, to find ourselves. Young people, girls and guys, shouldn't be getting married before the age of 18. I can see no good arguments as to why we should keep this practice alive in our state, and so I hope you join me in supporting HB 60. Thank you for your time, and I'm happy to answer questions if you have any.
Thank you very much. Are there any questions for Ms. Reagan? Seeing none, thank you very much for your testimony.
Thank you.
And up next is Amanda Parker.
Hi, this is Amanda Parker. Can you hear me now?
Yeah.
Thank you so much, Chair Rice, and for the distinguished committee members for prioritizing a hearing on this important legislation, and to Representative Levesque for her unrelenting leadership on this issue over the years. I'm Amanda Parker. I'm the Senior Director for the AHA Foundation. At the AHA Foundation, we work to end harmful practices including forced marriage, child marriage, and female genital mutilation in the U.S., including supporting survivors and at-risk individuals find safety and services. We were founded by Ayan Hirsi Ali, who herself is a survivor of forced marriage and female genital mutilation. I'm here today to record our strong support for HB 60, which would end all child marriage in the state without exceptions. I want to talk specifically today about the loopholes that allow for 16 and 17-year-olds to marry. The first is the parental consent loophole, which dates back to 1907 and which is also absurd. In AHA Foundation's experience, when a child is forced to marry, the perpetrators are almost always the parents. So parental consent is often parental coercion. Children can easily be forced or coerced into marriage or trapped into abusive marriages. Minors being forced or coerced into marriage may feel fear familial violence should they refuse to comply, or they may be physically or emotionally manipulated into accepting unwanted marriages. Minors may also not have the resources to find a way out of the situation. They face significant legal and practical barriers if they try to leave home, enter a domestic violence shelter, retain an attorney, get a credit card, or file a legal action such as divorce. This is why the AHA Foundation started working to fight child marriage in the US. It's because we had minors coming to us trying to seek escape from a forced marriage, and we were unable to use those normal tools that we would have available to us if we were working with an adult. The judicial review process is also deeply flawed. A judge is allowed, but not required, to interview a 16 or 17-year-old who seeks permission to marry without their parents present. Now, even if a judge opts to conduct such an interview, that does little to prevent a forced marriage and, in fact, introduces additional trauma to an already traumatic situation. It puts the onus on a terrified 16 or 17-year-old who is being forced to marry to choose between telling the truth and facing the repercussions back at home, or lying to the court. Whether or not the parents, guardians, and or the intended spouses are in the room when the interview is occurring, the 16 or 17-year-old knows that the family is going to figure out what happened during the interview based on the outcome. We have never heard of a single survivor going through a judicial review process when they were being forced to marry whoever chose to be honest with the court, whether or not they were alone during the court interview. A judge must conclude also that the marriage is in the best interest of the child, as we've heard. As we've also heard, the US State Department has called marriage before 18 a human rights abuse. And we've also heard about the numerous harms that are associated with child abuse or with child marriage right here in the United States. Now, how can something that we've deemed to be a human rights abuse ever be something that's deemed to be in the best interest of a child? It can't. Judges are prohibited from approving a marriage between parties with an age difference that constitutes statutory rape. This is pretty much pointless, though, because the age of consent is 16 and 16-year-olds are no longer allowed to marry in New Hampshire. The law also requires the marriage petition to indicate whether the Bureau of Child Protection has been involved with the child's family. However, it does not indicate what the judge should do with such information. Now, the solution is not to strengthen this judicial review process by adding more so-called safeguards. Even the most robust judicial review process has a fatal flaw. As I said, it puts the onus on children to find a safe way to communicate to a judge that they are being forced into marriage. This only causes further trauma in an already traumatic situation. Children are facing a horrible decision when they face that situation, being honest with the court or lying and feeling complicit in their own forced marriage. The parental consent and judicial review processes effectively disempower children, allowing adults to enter children into marriage and providing little or no recourse for children who do not want to marry. As you've heard today, child marriage severely limits opportunities to health, education, and economic freedom. It also increases the risk of domestic violence, and it almost always ends in divorce. Given these factors, one case of forced marriage is one too many. I urge each of you to vote favorably to advance HB 60 without delay. And I am so grateful for your time, and I also welcome any questions.
Great, thank you so much. Are there any questions for Ms. Parker? Seeing none, thank you very much for your testimony. And up next, we have Giovanna Ortiz Barrera. I hope I said that right.
Hi, yes, this is Giovanna Ortiz.
Hey, yeah.
Can you all hear me?
Yes, thank you.
Okay, wonderful. Thank you. Again, yes, I want to echo some of my peers and thanking you all in hearing us out today. Dear Chair Rice, Vice Chair DeSimone, and distinguished committee members, on behalf of UNICEF USA, I am testifying in support of House Bill 60, sponsored by Representative Cassandra LaBeouf, to make 18 years old the minimum age of marriage in the state of New Hampshire, with no exceptions. As a New England Community Engagement Associate here at UNICEF USA, I am constantly reminded how important it is that children have the right to be children. Too many children lose that right for too many reasons. One of those reasons is child marriage. Worldwide, more than 650 million women and girls alive today were married before their 18th birthday. Some of them are right here in the United States. In fact, an estimated 248,000 children as young as 12 were married in the United States from 2000 to 2010. Here in New Hampshire, between 2000 and 2017, 202 children were married as young as 14. UNICEF calls child marriage a harmful practice and a violation of child rights, and believes that marriage under the age of 18 should be prohibited in all circumstances. The elimination of child marriage is included in Sustainable Development Goal 5, which is working to achieve gender equality and empower all women and girls. The goal calls for an end to child marriage by 2030. In all cases, child marriage has negative impacts on children. It leads to separation from family and friends, a lack of freedom to interact with peers and participate in community activities, and decreased opportunities for education and economic participation. Because child marriage often results in child pregnancy, girls married at a young age face serious health risks. Teenage girls are much more likely to die in pregnancy and childbirth than women in their 20s. In addition, childhood pregnancy increases risks of nutritional deficiencies for both mother and baby, with permanent consequences. These risks are just as real for child marriages in the United States as they are in developing countries. For the sake of protecting children from abuse and protecting their futures, we believe every single U.S. state must take steps to ban child marriage. Child marriage is a violation of human rights and comes at a cost society cannot afford. On behalf of UNICEF USA, I urge you to take a stand for child rights and vote yes on House Bill 6C. Thank you all so much for your time and consideration.
Thank you very much. Are there any questions? Seeing none, thank you again for your testimony.
Thank you.
Up next is Michelle Hanash.
Good afternoon. My name is Michelle Hanash, and I'm testifying today in support of HB 60, the bill that would finally end the shameful practice of child marriage in New Hampshire. Marriage at 16 or 17 is extremely harmful and dangerous, and that is true even though a child in New Hampshire is currently emancipated automatically upon marriage. And here's why. Automatic emancipation does nothing, absolutely nothing, to prevent the forced marriage because the minor facing the forced marriage is not yet emancipated. So a child must first undergo the trauma of the forced marriage, which means being raped on the wedding night and often means being pulled out of school before she gets the right to escape. You cannot unrape a child by later emancipating her. The state of New Hampshire, in issuing that marriage license, is a party to the subjugation of that minor. For example, minors cannot easily escape an impending forced marriage just by leaving home, and domestic violence shelters will not take in children under the age of 18, and youth shelters are required to alert that minor's parents within 72 hours. And as you heard, minors often are not allowed to rent a hotel room. It is nearly impossible for a minor to obtain legal help, as contracts with children, including retainer agreements with attorneys, are voidable, and only the most generous attorney would agree to represent a child. It is also difficult for a child to obtain a protective order against parents forcing her to marry. Typically, children in New Hampshire cannot even initiate a legal proceeding or obtain a protective order without the assistance from a parent, guardian, or next friend. And the 83% of children marrying in New Hampshire who are girls marrying adult men face all these hurdles, while their adult spouses have no such handicaps. Also, since the court does not issue an order of limited emancipation with automatic emancipation upon marriage, as it typically would in an emancipation proceedings, it is entirely unclear whether a child married has the right to file for divorce or seek a protective order against an abusive spouse, or even leave home to escape an abusive spouse or unhappy marriage. Furthermore, automatic emancipation is very dangerous. It likely ends the parent's financial obligation without even evaluating the child's financial or emotional independence or educational needs. In other cases, minors cannot be emancipated unless they first show they have lived separately from their parents or legal guardians for at least 3 months, can financially support themselves, and have obtained or are pursuing a high school diploma or an equivalent certificate. The court looks at none of this when it automatically emancipates a minor just because they are married. And as you heard, as child marriage likely ends in divorce, the child can then be abandoned and ill-equipped to support herself or the children she is likely to now have. A child automatically emancipated through marriage and divorce before 18 may end up homeless if her parents refuse to allow her back home. Additionally, already emancipated children should not be allowed to marry. New Hampshire's emancipation statute allows children to petition the court for an order granting limited emancipation to the youth. However, such emancipation is intended to help children who cannot be reunited with their parents by giving them some limited rights of adulthood, such as living independently, managing their financial affairs, and entering contracts. It is unclear what other, if any, limited rights of adulthood are conferred, like being able to file a protective order or having the ability to navigate a contract as serious as marriage. As stated, domestic violence shelters typically also do not accept anyone under the age of 18, and it's unclear how emancipation would affect that rule. And imagine how a landlord might feel about renting an apartment to a 16 or 17-year-old, even one who is emancipated and legally allowed to rent the apartment. The law specifies also that an emancipated minor does not have the right to violate certain health and safety regulations relevant to the minor because of the minor's age, such as using or possessing tobacco or alcohol, possessing firearms, or gambling. Given the serious risks to child's health and safety that marriage poses, which is an increase in the likelihood of a myriad of physical and mental health problems, as well as increased risk of living in poverty and being beaten, the logical conclusion is that children also should not have the ability to be married. Marriage before 18 brings devastating, lifelong consequences for girls. The many repercussions of child marriage do not disappear if we stamp emancipated on a girl's forehead. Emancipated or not, marriage at 16 or 17 is too dangerous, and a child can wait to marry just as they would enter into any other contract. And I urge each of you to advance HB 60 and vote yes for those reasons. Thank you.
Thank you very much. Are there any questions for Ms. Nash? Okay, seeing none, thank you very much for your testimony. Up next is Sophia Bandolillo. I'm so sorry. Okay. Bandolillo. Is she there? Oh, there she is. She's right over here. You see her? Yeah. There we go. Sophia, there you go.
Hi, can you hear me?
Yes.
All right. Thank you, Madam Chair and members of the committee for taking my testimony today. My name is Sophia Biondolillo. I'm 14. I live in Manchester, and I am speaking today on behalf of the New Hampshire High School Democrats in support of HB 60. I'm in support of this bill because the marriage age in New Hampshire has been dangerously low for far too long. I remember when the marriage age was 13. I remember thinking that it was absurd that I, a child who could barely even manage getting my homework done, could make that sort of commitment to another person. And the fact is that keeping the marriage age as low as it is dangerous for youth and is rooted in traditions that should be long buried. First of all, most children who are at this stage in their life don't have a lot of experience with this type of reasoning or decision making. According to Stanford Children's Health, kids in their early adolescent development are just beginning to develop personal decision making skills and think about the future. At this pivotal stage in their development, I don't think it's reasonable or fair to put this type of decision in their hands. After all, if a 16-year-old can't be trusted to drive a car, drink alcohol, vote, or buy a house, why should they be able to get married? Marriage is also a somewhat permanent decision that can have long-term effects on the health of the person getting married. According to the International Council of Defense of Research on Women, International Council of Research on Women, those who are married in their teen years are at a much higher risk of becoming victims of domestic abuse and sexual assault. Equality Now, which is an organization dedicated to ending gender inequality and human trafficking, says the girls married as teens have higher risk for PTSD, depression, and certain heart conditions as well. So not only is this decision one that many minors aren't ready to make, it's something that could affect them long into their adult lives. Finally, the idea of child marriage is rooted in misogyny and hundreds of years of abuse. In the past, marrying young was often done out of a perceived economic necessity. This meant that a majority of child marriages affected immigrants, and to this day, most of the teens who get married in America are undereducated or impoverished. This so-called tradition needs to be abolished, and New Hampshire needs to step forward and protect the youth in our state. In conclusion, I urge the committee to support this bill in order to protect those most vulnerable in New Hampshire and treat our children with the respect they deserve.
Thank you very much. Are there any questions for Sophia? All right, seeing none, thank you very much for your testimony. Up next is Ella Pandaya. Who's not in the attendees list. Oh. So we will go to Sarah Tasneem.
Who's not on the attendees list.
Yes, she is. I see her. She's right. She's got her hand
Hi,
raised.
everybody. Can you hear me?
I'm sorry.
Yes.
Okay, thank you so much. Dear committee members, my name is Sarah Tasneem, and I'm here to give my testimony in support of House Bill 60. Thank you for bringing this bill forward. I think it's so important. My name is Sarah Tasneem again, and I'm a survivor of forced child marriage. I'm also a vocal national advocate to end child marriage in the United States because of the horrors I had to endure as a child with absolutely no escape, legal or otherwise. I hope that no other child must go through what I did, and that is why I support HB 60. I was forced into a marriage at 15 while visiting my father in California. I was living with my mom at the time, and she didn't know what was going on. I was introduced to a man that morning who was 13 years older than me. That night, that man became my husband in a forced spiritual ceremony. 6 months later, after being impregnated, I was forced to legally marry him. And it took me 8 long years of overcoming enormous obstacles, including physical abuse, sexual abuse, PTSD, anxiety, being taken out of school as a 15-year-old, and facing extreme poverty to be able to leave this man. I'm sorry. I am not the exception. I am actually the majority of minors who marry. We are 3 times more likely to be abused in our marriages. We're much more likely to be pulled out of school and face extreme poverty later on. We are at risk of having lifelong repercussions that we have to face throughout our lives. As a 15-year-old, I became pregnant right away. I had 2 more children, and I was left with the responsibility of caring for my kids after 8 long years of finally getting out of that marriage. It's taken me years to recover from the abuse, and it's taken me years to get back to where my peers are as far as education and finances. I just recently graduated with a master's in 2019. That said, most of my peers are just starting their families and already have their careers ahead of them. I am here to really say that on behalf of myself and for the people who can't be here to testify, I would urge you all to pass this bill because I can't think of any reason why New Hampshire would want to continue these harms and expose minors to a human rights abuse. And with that, I really appreciate all of you and all of your time. Thank you so much.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you very much. Up next is Elizabeth Sutton.
Thank you, Madam Chair and members of the committee. For the record, my name is Elizabeth Satan, and I am a child marriage survivor. It is my life's work to end this practice. I was 16 when I was forced to marry. while living in a cult in California. And I need to give you a little bit of context around this. My parents, that it's all relevant to the story, so I just want to tell you just a little bit about me. My parents divorced at 5, and my mother remarried a man who started a cult. And it had a culture of celibacy, of people marrying, dominance over people. And I was adopted by my stepfather when I was 11. So my father lost all legal rights to me, and he was unable to protect me. I was pulled out of school in 8th grade. And at 16, I fell in love with an 18-year-old. And they did not approve of that because it was a secret relationship, although I remained a virgin throughout. I was basically stripped in front. This is just the punishment that they gave me. I was confined to my room. I was brought to community meetings where I was stripped to my underwear with children watching. I was made an example of. I was shunned, and ultimately I was forced to get married. And otherwise I would have been an outcast there. I couldn't run away. I was a child. And at 16, I was forced to marry a 28-year-old after an engagement of 3 days. There were no questions by the clerk. There was no judge. And then I was taken to the South Pacific for 2.5 years. They took my passport. It was statutory rape. I basically lost consent over my body. I lost consent over my life. My dad was told after the wedding that I was married. And this man was obsessed with sex. On the 4th of July, 1984, when I was 19 years old, he showed some weakness about his being, basically being committed to the cult. And I seized on this, and I called his mother, who lived in a nearby city, and asked her if she could help us. And she delivered a car with the key on the tire. I escaped that evening and with him, and I went to see my father, who I hadn't seen in 12 years. The aftermath for me is I still have nightmares. I'm 53 years old. I have mental health issues. I've been through a lot of therapy. I'm still in therapy. I'm a mother of a 16-year-old. That's the age that I was married off. She still likes stuffed animals. She's only been on one date, and it was a picnic. I'm sorry. It's emotional for me. In the state of California, you can't tan until you're 18 in a tanning booth. Just a little relevance. This is not about religious freedom. It's a child protection issue. As you can see, the doors just kept closing for me. I was adopted. I was married. My passport was taken away. I would have been a runaway and I would have been returned to my parents. I had no options. Women in distress get help. Children in distress, married, do not. My story is actually a story of resilience. I became an international model at the age of 20. I got my master's degree, and I have a thriving career in healthcare. I am not the average child marriage survivor. Thank you for considering HB 60. I urge you to vote for it.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you very much. Up next is Aaliyah Abbas.
Yes, hi. Hi. Good afternoon, Chair Rice, Vice Chair DeSimone, and distinguished committee members. My name is Aliyah Abbas, and I am a child marriage survivor and an activist who will continue to fight until my whole country is free of child marriage. As a child marriage survivor, I request you to vote yes on Bill HB 60 because it simply will put an end to child marriage. Voting yes would mean eliminating the abuse of placing children in the most vulnerable, hopeless, and abusive situations. It is a fact that parental consent is most often parental coercion, as was in my case. Even though in this state, the marriage age is 18, but the law still permits 16 and 17-year-olds to marry with parental consent and judiciary approval. And like I said, in most cases, parental consent is parental coercion. The U.S. State Department has called marriage below 18 a human rights abuse, and a human rights abuse is never in the best interest of a child. Even a more robust judicial review process would be dangerous. It would put the child being forced to marry in the most terrifying position of choosing between being honest with the court or facing the consequences at home, or lying to the court. And if I were to be put into that situation with the type of family that I grew up in, I would be forced to lie. 17-year-olds are at the highest risk of being forced into marriage because they are close to graduating from high school, which is often when parents worry that children will become too independent and will choose to marry them off. I can attest to it, being that 17-year-old child bride 18 years ago. Child marriage destroys girls' health, education, and economic opportunities and increases their risk of experiencing further violence and trauma. Between 2000 and 2017, nearly 88% of child marriages were of children aged 16 and 17. So what does life look like for children who are forced into this abuse? To start off with, the children who are forced to endure this lifetime trauma of the forced marriage are also likely to be pulled out of school, just as I was. We know how important education is for children, especially girls. Child brides are physically, mentally, and emotionally abused and manipulated. Also raped before they could gain the rights they need to escape at 18. Child marriage, puts the health and well-being and safety of children into jeopardy. 70 to 80% of marriages before 18 end in failure, which puts children in such situations at risk of homelessness because they lack the financial independence. So what would we be really doing here other than putting the lives of these children at risks to all sorts of danger? I wholeheartedly support this bill because it hits home. It's extremely personal. I am a product of child marriage, and who better than a child bride to know the reality of this injustice? At 17 years old, in January of 2003, my senior year, I was taken out of school in Maryland, which is my home state, and I was flown to a foreign country where I was forced to marry a man who was 25 years old at that time, who was a complete stranger, within 3 weeks of being in that country, all without my consent. That one instance changed my life forever. The first night of my marriage, I was raped. I became a teenage mother without my consent to my 2 children. I had a DNC before that. And when I was at the hospital getting my DNC because the baby had lost its heartbeat, my ex-husband, who's still a stranger, was in Dubai, and he was enjoying, and he was partying. Being a mother is one of the most fulfilling jobs I have, but I will not lie, it took every ounce of my being to get to where I am today, and it still takes a toll. I can't even describe to you how much it took for me to, when I came back here 3 months after my marriage, how hard it was for me to graduate high school, but I still did it. I still held on to hope and to faith and to God, and I moved forward. I was pregnant and I went to college. I had my infant, my first child, and I took my child to college with me. I went to work with my children when the daycare would not accept them. Then I took both of my children to my classes with me, night classes. So yes, I went through college, I put myself through college, but I took every ounce of me, and I was only a child raising 2 children by myself. I cannot describe to you the feeling and the hardships that I went through. And a lot of child brides, it's a fact that they do not go through college. They do not get to finish high school. I don't know what it was, but I kept pushing, and I did not want to become that. I did not want to become part of the statistics. But I'm telling you, I still don't know how I did it today. And the marriage was, full of abuse. And when I totally forgot the name of the gentleman who spoke before when he talked about ownership. I am a very strong woman. I'm going to say that I do not let anybody own me. The only person who owns me is me. But my ex-husband, who was 25 years old, thought that he did own me. I fought back, and the consequences was more beatings, more torture, more rape, more physical abuse, more mental abuse, so while we may not think that, hey, nobody owns us, the abuser does think that they do. I wouldn't wish this experience for anyone. I was bullied, I was beaten, I was raped. I would just like to say one thing, that I never defined myself as a victim, even though I have been brutally victimized. I'm a survivor who had the courage to finally stand up for myself, and most importantly, for the sake of my children at any cost, even when the cost was death, as per my uncle. Because when we spoke about divorce, my uncle said, hey, the women in our culture, which is the Muslim, Pakistani, American culture, women are not, they're not allowed to get divorced. But I still took the step, knowing that I was going to risk death. I took the step, and I, got myself out of it. That is not the reality for a lot of girls who stay within these marriages. I didn't know how to swim in an ocean of uncertainty, but I took a huge risk toward my freedom and my children's freedom. I taught myself how to swim with that uncertainty. And it's still a process. It's a lifetime of healing. It's a lifetime of trauma. Unfortunately, most child brides do not get the opportunity to get out of this situation, and they experience a lifetime of abuse in all forms of dehumanization, torture, all types of abuse, and sadly, even death in some cases. HB 60 will simply end child marriage, and that is what we need to do. We need to step up and protect our children, our girls. Thank you so much for giving me this opportunity to speak. And I would just like to say I do have a speech impediment, and I did not let that get in the way today. Thank you so much.
Are there any questions? Great, seeing none, thank you very much for your testimony.
You're so welcome.
And up next, we have Freddie Rice, or Reese.
Hi, can you hear me? Yep, there you are. Oh, great. All right. Well, Chair Rice and distinguished committee members, thank you for this time. I am Frady Reese. I'm the founder and executive director of Unchained at Last, which works to end forced and child marriage in the U.S. And I am testifying today as both a forced marriage survivor and an expert whose research and writing on forced and child marriage have been published widely. I urge you to vote yes on HB 60 and end child marriage in New Hampshire. And I want to give a special thank you to Representative Levesque, who refuses to give up and was going to keep coming back, as will we, until New Hampshire ends child marriage. You've heard some powerful testimony today on all the reasons that we need to end child marriage, the harms and dangers of marriage, including at 16 and 17, the reasons the current law is not sufficient, the reasons that it should be 18, no exceptions when it comes to marriage. I want to touch on an issue. It's a question that comes up a lot. We at Unchained have spoken with many of you individually, and a question that comes up a lot is, what if a girl is pregnant? Isn't she better off getting married? Shouldn't she get married? And so I just want to talk about that, please. I want to make clear that there are only 6 US states that still allow a pregnancy to the marriage age, a pregnancy exception to the marriage age, because what legislators have realized is that marrying off pregnant teenage girls is terrible public policy. And states have moved away from this. In fact, most recently, South Carolina and Ohio just in 2019, Florida and Kentucky in 2018 have moved away from the pregnancy exceptions in their marriage age laws. And several states have passed legislation specifying that pregnancy is not enough of a reason to approve a child marriage. And here's why. 2 main reasons. First of all, policymakers used to believe that a pregnant teenage girl was better off getting married. And it turns out, studies show that pregnant teenage girls who stay single actually have better long-term outcomes than pregnant teenage girls who marry. For example, married teenage mothers in the United States are 40% more likely than unmarried teens to give birth to a second baby within 24 months. Teen mothers who marry while they're pregnant are less likely ever to return to school than teen mothers who do not marry. And that's really significant because we already know how significantly child marriage impacts education. You heard some of those statistics earlier. And also teenage mothers in the United States who marry and then divorce are more likely to suffer economic deprivation and instability than teenage mothers who stay single. And you heard again repeatedly today that those who marry as children are almost guaranteed to divorce. 70 to 80% of marriages before 18 end in divorce. The other really important reason that allowing pregnant girls to marry or marrying off pregnant girls is terrible public policy is that pregnancy exceptions to the marriage age have been used to cover up rape and to force girls to marry their rapists. You heard from several survivors today who talked about their experience being forced to marry their rapists. And this is something that we at Unchained, we provide direct services, and we have seen this repeatedly, is marriage used to cover up rape and to force girls to marry their rapist. Pregnant teenage girls are at an increased risk of forced marriage. This is what we have seen again and again. And if a girl gets pregnant and she is from a family or a community that views unwed motherhood as shameful, she is at a significantly increased risk of a forced child marriage, possibly to her own rapist. A girl like that needs more protection, not less protection. And I also want to make clear, there's always the question that comes up about co-parenting. Well, let's say they want to start a family and a girl is having a baby and wants to co-parent. Well, guess what? The father of a baby who wants to co-parent can easily do that outside of marriage. All he has to do is establish paternity. New Hampshire makes it extremely easy, like most states, to establish paternity. And that way the baby would be covered under the father's health insurance and other benefits. And a teenage girl could easily co-parent without being entered into this serious contract of marriage with all the harms that it brings. And you heard also how difficult it is for her to get out of that if she doesn't want it. And also, if the father does not want to co-parent, the mother could still does not need a marriage license to get relief. She could still petition the court to establish paternity and to enforce his basic obligation of support. New Hampshire law provides for that. And besides, think about how terrible the outcome would be if you try to force an unwilling father to co-parent by forcing him into a marriage. Also, be very clear that the federal government and most states no longer refer to a child born out of wedlock as illegitimate or treat such children differently. And indeed, New Hampshire law states that a father's obligations are identical whether the child was born of unwed parents or in wedlock. New Hampshire law already establishes that. And think about it also, if we want to make sure that no child is born so-called out of wedlock, then we would have to set the marriage age at the earliest age of puberty, which is approximately 8 and could be even younger. And I think we can all agree that setting the marriage age at 8 is not what we want to see. And so I just once again urge you to vote yes on HB 60 and end child marriage. 18, no exceptions. Doesn't matter if there is a pregnancy or not. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you once again for your testimony. So that's all I have on my list, and there was one hand raised. Yep, I'm getting there. Asma, I'm sorry, Asma El-Huni? I'm sorry, I know I just butchered that. There you go.
Sorry, can you hear me now? Yeah. Sorry about that. Yeah, can you hear me?
Yeah.
Oh, cool. So yeah, my name is Asma El-Huni, and I was married at 16 years old as well. I was no way at an age able to grow into an independent person at 16, nonetheless have a family. I did drop out of high school. I married someone who was 12 years older than me. It was a relationship that included control, manipulation, and abuse. I also got pregnant at 16, a child myself, and I got married in the state of New Jersey. Long story short, my marriage did wind up in a divorce. And I also just want to say that I disagree with the fact that this is always parent coercion. My parents didn't coerce me. I actually fell in love with a man that I thought I loved. Though my parents didn't want to let the marriage happen at such a young age, I would have still ran away with him if they didn't agree to it. So I just want to acknowledge that. And also I want to acknowledge that parent coercion does happen, and that's important to point that out. I also want to point out the response to one speaker saying that any relationship under 18 is manipulative. It's important that we don't label people under 18 automatically in a manipulative relationship, because people are going out with each other who are 16 and 17 years of age. Are all people under 18 in a manipulative relationship? No. But at the same time, I think that if people are in love at such a young age, below 18, they should just wait until they both are 18 before making the decision to get a legal marriage. So I support this bill, HB 60, because the possibility of coercion from parents sometimes is possible. It doesn't allow girls to grow into themselves because they're too busy taking care of families. And for me, my divorce, like, I had to go back to college and I only graduated 4 years ago. I am 44 years old now. So please do pass this bill, because it wasn't easy going back to school and getting my life back on track. And to also set the record straight, I am a Muslim woman. Unfortunately, someone said Muslim women can't get divorced, which is false information. But what is true is that some interpretations of the religion make it so that some make it hard for women to be able to get a divorce. But I needed to clarify that because I don't want my religion to be continuously stereotyped. Toxic patriarchal practices happen in all cultures, all religions, all countries. And so we need to work together to stop that. So please do support this bill and pass it for our community's sake. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you very much. We have one more person, Vivian Hamilton.
Thank you very much, Chair Rice and honorable committee members.
I'm Vivian Hamilton. I'm a professor of law at William & Mary School of Law, and I direct the William & Mary Center for Racial and Social Justice. I teach courses in family law, education law, race in the law, and federal civil procedure. I speak today in support of HB 60 to allow only adults aged 18 and over to marry. I do not consider myself an activist. Instead, I research how legal measures across a range of contexts affect adolescents. Most relevant to today's hearing, I published an article on the marriage age in the 2012 edition of the Boston University Law Review. As you've heard, in too many cases, minors are coerced into marrying. You've heard that minors, particularly girls, are vulnerable to this sort of coercion, either by their prospective spouses or by a girl's own parents. The importance of protecting children from the lifelong harms imposed by this sort of coercion is almost too plain for words. I'm focusing today, however, on the high social cost of early marriage, even when entered voluntarily, as the last speaker noted. And I'll try not to belabor some of the statistics that other speakers have shared with you. But as you've heard, women who marry in their teens are more likely to drop out of high school, less likely to finish college than those who delay marriage, more likely to live in poverty than those who delay marriage. Teen mothers who marry between conception and childbirth are less likely to ever return to school than those who delay marriage. I'd also like to just emphasize for you that they are more likely to have a rapid second birth than teen mothers who don't marry. They're also more likely to have more children overall. Both closely spaced births and having 2 or more children are associated with lower educational attainment. There are other social costs, including psychological costs. A study reported by the New York Times found that teen marriage was significantly associated with mental disorders for women, particularly major depressive disorder. It also correlates with worse physical health for women, putting them at greater risk of heart attack, diabetes, cancer, and stroke. Now, to quote the National Marriage Project, quote, "Age at marriage is the strongest and most consistent predictor of marital stability ever found by social science research," end quote. So we're all probably familiar with the statistic that nearly half of all US marriages end in divorce. When we break that statistic down, however, we see consistently and over decades the following. For individuals who delay marrying into their mid-20s, fewer than 30% will divorce. When individuals marry before 18, as happens in New Hampshire, nearly 70% will divorce. When children marry at age 16, as happens in New Hampshire, nearly 80% will divorce. I want to emphasize as well that these rates of marital failure hold even when parents consent to minors' marriages, and they hold even when judges consent. Delaying marriage by even a single year, on the other hand, significantly reduces the odds of divorce. You might be wondering, after all of this testimony, why are the marriages of the young so unstable? It's a complex issue, but it seems to roughly boil down, according to research, to 2 factors. The first is economic. Into the mid-20th century, a young person didn't need to graduate high school in order to obtain a blue-collar job that paid a wage sufficient to support a family. To earn a wage sufficient to support a family in today's economy requires more years of education and training than can typically be acquired before age 18. Low-paying work and occupational instability hinders the ability to support a family, and financial insecurity stresses the marital relationship. The second factor is relational. The meaning of marriage has evolved over the centuries and decades. Today, marriage carries greater symbolic and personal value than ever. We expect of our spouses a degree of relational intimacy and connection far greater than in the past. Today, we no longer just expect a good provider. For better or for worse, we now expect a soulmate. As a result, today's marriages require mature relational capacities, and these depend on a level of psychosocial maturity that adolescents lack. Finally, in closing, we might ask, why should we care that most young people who marry then divorce? Because at least some of those marriages last, right? Well, this is why we should care. Marriage is arguably the primary social institution in the US and in New Hampshire. It's a civil status. When it's created by the state, when the state gives its stamp of approval, it's saying this relationship is good for these individuals, it's good for their families, and it's good for our society. We encourage this. But as you've heard, for these minors, marriage is not a good. It overwhelmingly hinders their well-being, their future, their ability to reach their potential, and what they are ultimately able to contribute to society. So underage marriage is also not good for broader society. For those reasons, I argue and hope that you will agree that our states should no longer sanction child marriage. Thank you so much for your time.
Thank you very much. Are there any questions? Seeing none, thank you very much. So I see that there is someone else has raised their hand in the attendees list. I would ask that any testimony you give not be an echo of everything that we've already heard, because we keep hearing the same testimony. So I'm going to call on Rima Nashibi.
Thank you. Thank you, Chair Rice, Vice Chair DeSimone, and other distinguished reps. I'm the founder and president of Global Hope 365, which is a 501c3 nonprofit organization dedicated to improving the lives of women and girls locally and nationally. And our goal is to end harmful practices against women and girls like child marriage, human trafficking, and other types of other forms of gender-based violence, domestic violence. I'm not going to repeat anything that was said before. I just want to bring your attention to one thing. A couple of things. A number of the child marriage survivors indicated parental consent is parental coercion. The Office of the United Nations on Drugs and Crime issued a report recently on the interlinkages between forced child marriage and human trafficking, which, as we all know, involves fraud, force, and coercion, and benefiting commercially from the use and abuse of another human being. So fraud, force, and coercion is included in both child marriage and human trafficking. In addition, the American Medical Association has passed a resolution and has called for an end to child marriage, stating child marriage is associated with higher rates of sexually transmitted infections, infant and maternal mortality, early pregnancies, divorce, and intimate partner violence than compared to women married at the age of 21. Thank you. That's all what I wanted to say, because the rest of my testimony, which I emailed, is a repeat of what everybody else said.
Thank you very much. Are there any questions? Okay, seeing none. Thank you again. And I see no more hands raised, so I am going to close the hearing on House Bill 60. Committee members, we are going to take about a 5-minute break and then come back and exec 2 bills. We're going to do HB 427 and HB 254. Okay? I'm good. So committee members, your cameras will have to be on in order to vote during the exec session, just so you know. So we'll be back in, say, 3:40. Give us a few more minutes.
يلا مالي. يلا.
Can you hear me?
Yes, thank you.
Okay. Welcome back, everyone. Oh, we have to wait for the clerk. Hold on. I can't start without her. Nope. There she is. Okay. So I'm going to, oh my. So why does this mouse make this hand? There was a hand on your shoulder, Rep. Altschuler, and I was like, what's happening? It was the mouse. Okay, so we're in the executive session on House Bill 427. And I'll recognize Representative Altschuler to move.
Thank you. At 1:05 this afternoon, every member of the committee received an email, which is a resend of the amendment you got last week from OLS to House Bill 427. And I move the amendment be adopted.
Second. And it was seconded by Representative DeSimone. Would you like to speak to your motion?
Sure. In section, if you're looking at the original bill, section 2A, so it would be line 7 in the original bill, will now be, that whole section A will be replaced, and it actually just adds in, if you look on line 5 of the amendment, it adds in the words, agency shall include any public or private entity under contract or agreement with the Department of Health and Human Services. So the two words "or agreement" are the addition, and this is a request for a clarification in the language by the Office of the Child Advocate.
Great. Is there any further discussion? Representative Cross, can you turn on your camera? I know you're here, but because you're on the screen too, it looks like you're not. So we have to take a roll call on adopting the amendment. Is that correct, Christina?
Yes.
Okay.
Yep, that works.
So I will have the clerk call the roll on the adoption of amendment number 20210149H. You're muted, Representative Alicia.
I'm sorry, would you repeat the adoption number?
2021-0149H.
Thank you. Christina, can you hear me?
Yes, I can.
Okay, so the sheet that you just sent me is different than the one I have, so I'm going to use the one I have because it's a piece of paper in my hand.
Okay, that's fine.
Okay, thank you. All right. Representative DeSimone?
Yes.
Representative Yokella?
Yes.
Representative Lewicki?
Yes.
Representative Belanger?
Yes.
Representative Cross?
Yes.
Representative Litchfield?
Yes.
Representative Smith?
Yes.
Representative Long?
Yes.
Representative Alicea? Yes. Representative Grossman?
Yes.
Representative Levesque?
Yes.
Representative Wazier,
Yes.
Representative Patrigno,
Yes.
Representative Hutschiller. Representative Madam Chair Rice,
Yes.
it's 15-0 is the vote. The amendment passes.
Is adopted. Representative Ashton.
It's adopted. Thank you.
I move that House Bill 427 as amended, OTP.
So OTPA is your motion?
OTPA. There you go. That too.
Who said that, please? Who made the motion, please?
Representative Altshuler.
Representative Rice seconded.
Representative DeSimone,
Yes.
Representative Yokella,
Yes.
Representative Lewicki,
Yes.
Representative Belanger,
Yes.
Representative Cross,
Yes.
Representative Litchfield,
Yes.
Representative Smith,
Yes.
Representative Long,
Yes.
Representative Ali Saya, yes. Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Wazir,
Yes.
Representative Patrigno,
Yes.
Representative Schiller,
Yes.
15-0.
Madam Chair votes yes.
Madam Chair, Representative Rice, thank you.
Without objection, we can put it on the consent calendar. Yeah, that's right. Yeah. I'm going to give the clerk a minute to catch up.
While we do that, can you just explain to me what is the session, what this is all about, and what the end result is?
Okay.
So exec session is when we vote on the bills that we have. So we just held the exec session for 427, and we're gonna do an exec session for 254. And what we do is we make a recommendation to the House floor. So it will go in the calendar, whoever makes the motion. So for example, Representative Altshuler made the motion, ought to pass as amended. So she'll be writing the committee report, not me. I don't like writing committee reports. And that's what, and if it had been, okay, say that had been the majority vote, but there was a minority, someone else could write a minority report. So you get
good
versions of it in the calendar, right? But because this was unanimous and it doesn't have a fiscal note, it can go on the consent calendar. The consent calendar is at the beginning of our calendar at every House session, we take one vote for the entire consent calendar. Now, if there's a bill on there that you don't agree with and you want to pull it off, you can do that ahead of time. You have to let the clerk know, and then you can fight it on the House floor. But usually, when we, we'll put it on consent and it usually stays there unless there's something, hugely unforeseen. But so that's what we're doing is we're voting on these, and I chose these two today because there really wasn't a lot of discrepancy in the bills. So be an easy first time going through. So if there's an amendment, we move the amendment, and then someone would move ought to pass as amended, and then we vote on it, and, you know, but, and we'll have some discussion, especially on the ones that, you know, we may not all agree on. So that's what we're doing, and I apologize for not going into detail for the new people. Shame on me. I hope I did okay. Did I cover everything, Pat? Yeah? Okay. All right, so next we're going to move on to House Bill 254. And I would like to move Amendment 2021-0140H.
I'll second that, Madam Chair.
Thank you. And that was seconded by Representative DeSimone.
Can you?
This was the that we have spoke. Yeah, I'm going to get to you, Representative Yocella. Let me speak to my motion.
No, before you start talking, can you repeat the number so that we can all look at what you're talking about when you speak to the motion? Can you repeat that number?
10140H. And it was sent to you last week when we had the public hearing, and the people in here had the hard copies.
Are you ready to vote, Madam Chair?
No, I'm gonna speak to my motion first.
Okay.
So this was the amendment that we had talked about that replaced the bill. It took out the care management entities in it and just helps to reduce the amount of kids being sent to Sununu Center. We had done it a few years ago. At the time, I was against that, but it's been very successful. We now have more community services out in the communities. The funding has gone out. So I think it's safe to, you know, let's keep these kids back in their communities and not in a prison setting, jail, lockdown. So Representative Yocella, did you have something to say?
I'm still looking for the amendment, so you'll have to go on without me, I guess.
I put it in my email.
I searched for 254 and it doesn't seem to be coming up under that.
Wait, I have it right here. Hold on one second. And I will forward it to you. Does anybody else need it?
Yes, if you could send it to the whole caucus, because I don't have it either.
Right.
Okay. Okay, hold on. So I don't know how to do this.
Just forward it to CFL Children Caucus, you know, Children Family Law Committee.
Oh, there it is. Okay, thank you. I was freaking out thinking I had to type in everything. Okay, I sent it, so.
No, it's not attached.
What do you mean it's not?
You just forwarded the text, but not the actual thing. But I should be able to search from that language, see if I have it here somewhere.
Forward and include.
There we go.
So CFL.
See it now.
There you go. I hit include attachment. Did you get it?
Yes, I received it.
Yep.
Okay. I'm sorry, Representative Atwood, do you have a question? Okay, I saw your hand up.
Put your hand down. I think you just wanted to copy of.
Yeah. Representative Lewicki.
Madam Chair, I believe we may not all be getting all of the emails. I'm going to have to, and if we aren't, obviously we can't know it. And so.
You didn't get it?
No, I can't know right now whether I did or not, but I believe that there are some that were mentioned today that I did not get. And so we've got to make sure that that's not happening, because obviously people will be left.
Yeah, so check with House Committee Services. I'll have them check on that.
Okay, thank you.
Okay. Okay. Representative Yocella? No? Yes?
Sure. Thank you. I will. My concern with this amendment is that it doesn't seem to fully address the concerns brought up as we go from a list of things that are saying like everything except this can be put into Sununu Center, and going to a list of everything but this is allowed to go to, or only this is allowed to go to.
Only this.
Yes, the list of only, and there are a number of crimes that was brought up in committee that said that there was concern that some of the things were violent that wouldn't be allowed to go to the Sununu Center, and that the placement options for people convicted of those crimes may be limited, including no option for placement because the crime is a type of crime that facility has no capability of securely serving that person, whether it be protecting them or segregating them off from other people or whatever the reason may be. There was some concern mentioned about that, and I don't feel that it's been adequately addressed. One of the things I got a list of some of the potential things that may cause harm, cause conflict, and I think that it would be best that this committee go into kind of a work session or something like that to address and make sure that all of these potential crimes could be serviced outside of the Sununu Center. And until that has happened, I'm not sure that this change is appropriate because I don't think that we have enough information